Divisionments matter, pronouncement of judgment, Criminal Appeal 27/2023.
The conviction of the appellant is set aside. He is given the benefit of doubt and he is acquitted forthwith.
Item 48, single bench, pronouncement of judgment.
The meetings of the selection committee dated 25/6/2015, as well as the notification dated 29/6/2015, as well as the order and the memo dated 30/6/2015, are all set aside. Taking note of the fact that the petitioner has been agitating this matter since 2015 and respondent numbers 4 and 5 have rendered service for about 9 years, it is provided it would be open to the respondent authorities to conduct a fresh recruitment process for filling up the 2 vacant posts of junior assistant in the Office of the District Industries and Commerce Center, Golaghat, and provide for giving extra weightage to the petitioner and the respondent numbers 4 and 5, and to condone their age for applying for and for entry into service if selected. Yes.
Mention. Mention for adjournment only.
Yes.
May please, Your Lordship. With the consent of other side, my lord, I beg to mention item number 15 of today's list, my lord. Lord, 2 weeks time may kindly be allowed to file reply affidavit, my lord, to the affidavit filed by respondent number 5.
Okay. You have informed them?
Yes, my lord.
Oh,
I am for the response.
Both sides are represented on the prayer made by legal counsel for the petitioner. List after
3 weeks, my lord.
3 weeks, so as to enable him to file affidavit in replying the matter.
All right.
Any interim order is there? No. Any interim order is operating?
No, no. My lord, my lord, regarding the item number 5, my lord, this item I may be allowed to withdraw this matter, my lord.
Okay,
There is subsequently some development in this case, my lord.
okay. Upon instructions, Mr. V. Kumar, legal counsel for the petitioner, seeks to withdraw this late petition on the ground that the subsequent developments in the matter. Mr. DHI will be there, CGC. Okay, Mr. A.R. Adhikari, learned CGC. MR Adhikari, learned CGC is present. Matters are dismissed from withdrawal.
My.
I have to mention item 11. In this matter, my lord, I failed to annex one important document, my lord. May I pray that I may be allowed to withdraw and liberty to file afresh, my lord.
Okay, both sides are represented. Upon instructions, Mr. M.R. Adhikari, the counsel for the petitioner seeks to withdraw this petition as an important document was left out. So he also prays for liberty to approach the court again. If a prayer is allowed, matter since dismissed on withdraw with liberty as paid for.
My lord.
Please, my lord. With the consent of other side, I beg to mention item number 36.
36.
36 of the daily list. 2 weeks time may be granted to impede the incumbent officers. It's a contempt.
Okay, you have informed the other side.
Yes.
Okay. Both sides are represented on the prayer made by the counsel for the respondent to list after
2 weeks, Lordship.
2 weeks was to enable the said respondent to file affidavit in opposition in the matter.
I'll oblige.
Yes, Mr. Lordship. On behalf of my senior, my lord, and with the consent of the other side, I'd like to mention item 18, my lord. This matter may kindly be adjourned for 2 weeks, my lord.
Item number
18, my lord.
18, okay. Both sides are represented on the prayer made by Mrs. S. Borpatro Bhai, learned counsel for the petitioner. Matter stands adjourned today, list after
For 3 weeks, my lord.
3 weeks.
But there's an interim order also, my lord.
Okay. Interim order passed today, stands extended till the next date of listing.
I'd like to request for listing of WPC 632.
Give it to the court master.
May I question?
Hey, mention
Mention
that.
this matter for listing, my lord.
And give it to the court master.
I may, mention item number 50. This matter may adjourn for the day of
15 or 50?
50, 50,
After?
2 weeks, 2 weeks.
Yes. So 50 is a review matter pending since 2018. No, you'll have to wait till the matter is called. Renew the prayer when the matter is called. It's a review petition of 2018.
Next.
Yes.
I like to mention item number 16, Lordship. Item number 16.
16.
16.
You have the petition for the petitioner.
I am for the petitioner. Be on behalf of BK Gogoi.
Both sides are represented on the prayer made by land counsel for the petitioner. Matter stands adjourned today, list after 2 weeks.
Oh, next.
Daily list item 1 for motion.
Wait, please, Lord. Matter is relating to non-compliance of the order dated 22/9/2022. Passed by this honorable High Court, my lord.
22/9/22.
Yes, my lord. Order is at page 38
For the petitioner.
and the relevant portion
Content,
at para 10, page 45.
content issue notice. Steps within 2 days. Pendency of the requisition shall not be barred for the respondent to comply with the order of the court. Take the comment from here.
Oblige.
5 weeks.
Item 2.
Lordship, this matter relating to a compassionate abandonment, Lordship. The petitioner's father was serving as a Khalasi.
Just a
Lordship.
moment. You took time on the last occasion to obtain instruction, Mr. Upadhyay.
My lord, I have received one instruction on dated 2/5/2024. They are only forwarding the DLC meeting minutes. I have seen the DLC minutes, my lord. The minutes, my lord, recommendation is made, but in the column, they have not mentioned any vacancy.
No, it's there. Vacancy is there. There's a clear vacancy of
Yes,
one
Page 18.
junior assistant. There is
Yes, I have
vacancy.
seen the last page. So SLC says, my lord, 5% vacancy is
No,
not
Mr.
there.
Upadhyay was asked to obtain instructions. You got it? No.
Now, it is up to Dr. Mohan.
Oh, achha, okay.
The vacancy is there, my lord, department says, my lordship may dispose of the matter with a direction that there is a vacancy that you may consider.
Yes.
In fact, my lord, I asked them to, my lord, submit the instruction whether 5% quota vacancy is available or not. But instead of that, my lord, they have sending only the, my lord, the DLC minor.
Which page that
Page
vacancy is
18,
there?
Lordship.
Which page?
Page 18, Lordship. And
18.
18, one. Serial number 1, Lordship, column number 3, name of post, junior assistant. Now, Lordship will see last column, column number 7, number of posts under 5% quota. That is 1, Lordship.
We are issuing a notice, we are not disposing it of. Otherwise, again, there will be second round of litigation. Let us stop here. They will tell us why they have not given, and if not, they will put it up again.
Last third occasion, they have taken time, Lordship.
Huh?
Yes.
For third occasion, they have taken time on 4th of March.
It's okay. That is not material. But Mr. S.U. Ahmed Kagan, counsel for the petitioner.
I am for 1, 2, and 3.
B.
No, but 2 and 3, my lord.
1 and 4, I.
Yes.
But you'll have to tell us, Mr. Ahmed,
Yes, Lordship.
why in 2010 your father died? Why should we entertain the writ petition now?
Lordship, I was facing the matter, Lordship, but time and again, they are saying that it will consider. And
No, but
Lordship,
after you see, there is a judgment of the Supreme Court which says that after all these years, it can't be considered. In fact, we can't.
but that issue is not, Lordship. Now the SLC has considered, Lordship. I am on the issue of SLC. Not, I am not.
No, but you see, if independently it can be done, that is okay. But the court will not issue a writ because the Supreme Court has come down very heavily.
That issue is different, Lordship. But they have considered my case, but that ground of
No, but
rejection is different.
you see, there can't be a judicial order of the court. If they have considered it, that's okay.
Yes.
But the order of the court will not be there.
Let them come with the affidavit, Lordship.
No. You see, allowing them to come with affidavit is different matter.
Yes.
But 2010, you have to show us why it should be entertained after 14 years.
2010 matter, my lord.
But
Because
Lordship,
we will be
the
dismissing your
SLC,
writ petition.
the district level committee meeting are not held. Time and again, considering. Now they have considered, Lordship. DLC passed and recommended, and SLC not considered, but the way they have
You see,
rejected, that is illegal.
whatever the cause of delay, even if the authorities are in delay, then also we can't consider.
I'm not.
The Supreme Court is coming down very heavily. It can't be considered. So, I will be disputing our writ petition.
When recommending it, they have has not mentioned the 5% quota. DLC.
No,
No,
DLC
that's
actually,
okay. 5% quota,
recommended.
now you are under the new 2015. But 2010,
DLC held, Lordship, in 22, Lordship. Kindly see, Lordship. DLC meeting held.
no, Mr. Ahmed, you have to answer legally.
Yes,
Because the Supreme Court says that after so long,
yes.
you can't consider. The courts are barred from entertaining these writ petitions.
In the Robert case, my lord.
They were the,
Yes.
Lordship, I'm not aware of that judgment, Lordship. Lordship, and let them come with the affidavit. I will check it up, Lordship.
no,
Affidavit, we have no instruction of what affidavit I will file.
no. You see, 2023, AI 2023, they will give it to you.
Yes,
They
sir,
were
they
the
forgot.
second.
But Lordship, here, I am not aware about those judgment, Lordship.
It's not a question of being aware, you see, because the 2010,
Yes,
you'll have-
Lordship.
otherwise you'll have to satisfy why 2010.
2023 SC, my lord, 1467.
Normally, what happened, Lordship, and in compassion department, that authorities are not,
No,
they
it
are
should have come
approaching, they are
earlier.
saying it will be
It should have come earlier. We
considered
can't
in your
entertain-
turn, Lordship.
No, Mr. Ahmed, we'll have to dismiss your writ petition.
Lordship.
Uh,
And Lordship, the fact is that, Lordship, in
No, we'll make a mention. We'll
prior
take
to
order-
2017, after
No, in
2017, it was
also after
prorogated, Lordship.
consideration, 2 years has passed.
We'll record your submission in the order.
Lordship, sometime may be given, Lordship. Let me go through the. Next, maybe come next to lordship, only 1% lordship, since I am not ever lordship.
Friday. On the prayer made by Mr. Asif Ahmed and counsel for the petitioner, let us adjourn today. Mr. P. Sudhir, additional senior government advocate, and standing for N. Upadhyay, London, standing counsel for the Irrigation Department are present. Friday.
17.5. Item 3.
Yes, Mr. Dhawal, good to see you again. You vanish and then come back again.
My lord, somehow alive, your lord. My lord, you will find, my lord, that this writ application is against the impugned order, my lord, at page 48. Rejecting the application filed by the present petitioner, your lordship, for fixation of her seniority, my lord, and to publish the gradation list, my lord, in accordance with the statutory rules. Now, my lord, that representation filed by the, my lord, the petitioner has been rejected by this.
No, but your service has been regularized.
Her service was regularized, dear lords. Now, if it is regularized or confirmed, my lord, in the statutory rules, it has been no word regularization is there. Here is the
What is-
word confirmation.
What is the date of your confirmation?
Confirmation, my lord, my date of confirmation, my lord, which was on, my lord, 16/10/1996. I passed the departmental examination. But ultimately, 5 years, my lord, they issued a notification, your lordship.
Where
And
is that?
thereby regularized my service with effect from 27/4/2001. Now statutory rules all through, my lord, states that the seniority.
No, you see, there's a date, that date is given for a purpose, because it is on that day that the cabinet took the effect of regularization was given.
Firstly, my lord, your lordship, my lord, may see the rules, your lordship. I take your lordship to the rules, my lord. At page, your lordship will find, my lord, 63. That is the rules, my lord. They had furnished
Page
us,
63.
my lord, in reply to an RTA application.
Yes.
Now, 63 seniority, your lordship.
Yes.
Now, rule 2 years, lord, sub-rule 2, your lordship, may kindly see. If a member fails to join in the appointment within initial 15 days on receipt of the order or with the extended period as mentioned in Rule 17, but joins later, his seniority shall be determined in accordance with the date of joining. Now, my lord, now, my lord, rules 21, your lordship. Next rules. Now, my lord, all appointments are initially on probation, my lord. Now, my lord, they are to pass the examination.
Where is that provision?
Now, my lord, rule 21, sub-rule 3, your lordship may see. If confirmation of a member is delayed on account of his failure to qualify for such confirmation, he shall lose his position in order of seniority, such as his juniors, as might be confirmed earlier than his seniority. Now, his seniority shall, however, be restored on his confirmation, that is regularization, subsequently, your lordship. So, as soon as I passed, my lord, this qualification, my lord, this examination, my lord, then my seniority is to be restored, your lord. Now, annexure 3, your lordship, may kindly see, my lord.
Page.
Annexure 3.
Page.
Annexure 3, your lordship will find, my lord, at page 33, your lordship. Here, my lord, this is the order of the government, my lord. Government says that it should be, my lord, in accordance with the date of joining, my lord, page 36. Or your lordship may kindly see, my lord, we have given a typed copy at page 33, your lordship. Now, my lord, in partial modification of the Chief Engineer Irrigation Office number 7, the Governor of Assam is pleased to regularize the service of following engineers with effect from the date of joining. So always, my lord, it is a date of joining, and this particular notification, your lordship will find, was issued by the Commissioner and Secretary, my lord, a higher authority, your lord.
Yes.
Then your lordship may kindly turn, my lord, to page, my lord, 38.
Okay, I'm issuing notice.
Annexure 4, your lordship.
Okay, we are issuing notice. Let me stand Dhawal and counsel for the petitioner.
And peculiar fact, my lord, 1 minute, my lord, I will take. My lord, peculiar fact, in this way, for the last 33 years, my lord, 30 years, she is working in the same post without any promotion. 30 years has passed by since he has joined in her duty. Accordingly, I have an interim prayer also, my lord, you can consider.
No. If you see, if you are asking for a, for your regularization from an anti-date, then you'll have to array all those people who are in the select list as a respondent. Otherwise, your petition will be back from
My lord,
non-joint
so
or
far as-
necessary party.
my lord, it is up to your lordship so far as interim order. Otherwise,
No,
my
no,
lord,
no. Even for the
otherwise,
main-
my lord, gradation list, if your lordship goes to the gradation list, all the persons who have been appointed, my lord, promoted in the meantime, they are included in this list, my lord. And if they are eliminated, my lord, as they are promoted, then I am the person to be, my lord, promoted.
No. You are seeking your regularization from a date ante to what is ordered, 2001.
So, my lord,
Now you are
then,
seeking.
my lord, your lordship may see that, my lord, until further order, no promotion to the next higher rank.
No, that can't happen. People who are affected are not parties.
Yes. Yes.
If you are
Private
seeking,
persons, my
if you
lord,
are
they had
seeking an
retired.
antedate,
Those who are above me, they have already, my lord, somebody was promoted, some others retired, my lord, I have given a statement.
so you'll have to make a statement that your what you call your regularization will not adversely affect any other person.
And, my
You'll
lord,
come to the same stage then.
promotion could be given, my lord, without affecting the seniority of others. Now, my lord,
Then it
paragraph
can't
10.
happen. Then your writ petition has to be dismissed.
Now, my
You
lord,
see-
that is up to your lordship.
No. This is how I'm putting a legal
No,
question.
so
You
far
may
as-
have a legal answer.
So far as interim, my lord, let that.
You see,
please go, my lord.
you say that your others, promotion of others or the seniority of others will not be curtailed. Now you are claiming that your
My lord, your
the
lordship
date of
may issue
appointment.
notice on the interim order.
No,
Let the
no.
authority come.
Please have a legal answer to the query. You see, the question of the court is your regularization order is of 2001,
Ah,
correct?
23.
Now you are seeking a direction by which your regularization will be from 94 or 96.
Yes.
It should have been from
No,
96.
it's okay.
From the date of joining.
So from the date of joining, whenever it is, to 94, 96, whenever. So if your regularization is antedated, there'll be many people who will be affected.
My lord, if I was regular, my lord, passed the qualification, my lord, examination, the departmental examination, your lordship, in 1996, then at least my service should have been, my date of, my lord, seniority should have been with effect from 96. That was
Well,
not done.
There are many Supreme Court judgments and even judgments authored in this court where we have said that if your challenge adversely affects others, then there is a non-joint or necessary party. And second is the well laid down ratio that if by your challenge others are adversely affected, then belated challenge should not be entertained. You see, from 2001, you are antedating your seniority to 1994. So if it is 1994, you have been wrongly victimized, everything is okay. But if you are made 2001, then somebody will be adversely affected. Even one person will be adversely affected.
My lord, I have given a statement accordingly, my lord. That is the reason for non-including the others above my seniority, my lord, seniority list.
Then
your
you will be
lordship.
dismissing your
Paragraph
petition.
10, your lordship.
Then
Paragraph
you will be
10,
dismissing your petition.
Paragraph petition.
Because then
Or,
will
my
be,
lord, your lordship, my lord, either may fix a date for considering the interim order, or your lordship may not be given, let the notice go.
no, I am not even issuing a notice. I'll be dismissing
Yes,
your
my
writ
lord,
petition.
let the notice go, let them file affidavit.
No, I'll be dismissing your writ petition. For non-jointer, we can't entertain a writ petition.
So, my lord, then if they are, my lord, if your lordship thinks, my lord, they are the proper party, then, my lord, we can add them.
Do it.
We
We
can
adjourn the
add them.
matter.
We will add them.
Okay.
Your lordship may
But Mr.
pass an
N.
order
Dhor,
to
learned
the
counsel
effect.
for the petitioner, and Mr. N. Upadhyay, learned standing also for the irrigation department.
For all the respondents.
Next, madam. The petitioner claims
Can ভেবেছিলাম এদেরকে add করা ভেবেছিলাম কিছু নাই তো add করা যায় ওটা
What will be your date of, what will be your date of joining, Mr.?
Date of joining, my lord, 12/3/1993, your lord. My lord, 12/2/1993. I was appointed on 10/2/1993, paragraph 3, my lord, of the writ petition, page 5. Page 27, page 5.
The claims I have joined
First quotation,
service as
joining.
junior engineer within bracket civil. Oh, sorry, electrical on 12/2/1993. And as the petitioner had cleared the departmental examination successfully,
Page 27, your lordship, I passed the departmental exam. And statement, my lord,
on
Statement three,
on 10,
paragraph three.
on 16/10/1996, comma, the by operation of which section in this act, the service rules, which rule? Which rule?
My lord, rules is Assam.
No, which
Subordinate Engineer
which particular rule?
Irrigation.
Which
Madam,
particular rule?
Rule 21. किसे कहते हैं?
21(3).
Confirmation, my lord, so far as
By
comes
operation
to
of Rule 21 within bracket 3, comma, the confirmation of
Rule
service of the petitioner ought to have been given with effect from 12/2/1993.
21.
However, the
Page 63.
however, by virtue of notification dated 3/4/2002, comma, the the regularization of the confirmation of service of the petitioner was given effect from 27/4/2001. First of, accordingly, by claiming that the date of confirmation of the petitioner ought to have been 12/2/1993, the present date petition has been filed under Article 226 of the Constitution of India. First of, although next paragraph, although a statement has been made in paragraph 10 of the petition to justify why the other affected persons have not been arrayed as respondents, The court is of the considered opinion that if the date of confirmation of the service of the petitioner is allowed to be considered from 12/2/1993, there will be several persons who will be affected by that. Accordingly, on the query of the court as to whether the writ petition is bad for non-general or necessary parties, the learned counsel for the petitioner pays for some time to implead those the others as respondents in this matter. Accordingly, by this matter stands adjourned today. How much time?
1 week. 1 week.
Uh, List after a week, by which time the necessary application shall be filed by the petitioner.
Item 4.
May I please, your lordship kindly pass over for the time being, my scenario on live.
Just a moment. We'll issue a writ petition, notice of motion here. We're issuing a notice of
My
motion
lord,
here.
actually, my lord, in fact, my lord, the information which was sought, my lord, already is furnished to her also,
Okay,
already furnished.
it's furnished. We'll issue a notice then. 2
My lord,
weeks.
your lordship,
2 weeks.
my lord.
Okay. Your name?
Visit Mena, A Mena.
A. Meena, learned counsel for the, heard Mr. A. Meena, counsel for the petitioner. Also heard Mr. T. G. Mohantal and its senior counsel, assisted by Ms. P. Sharma, the standing counsel for the APSC. Next paragraph. Pursuant to order dated 9/4/2024, the learned senior counsel for the respondents, APSC, has submitted that the information sought for by the petitioner has been furnished. Next paragraph. Is there resume? Issue notice returnable. Issue notice including notice on the prayer for interim relief returnable. Give a date after 2 weeks. Consequence so. As the as Mr. P. Sutyal, additional senior government advocate, accepts notice on behalf of respondent numbers 1, 2. And Ms. P. Sharma, the standing counsel for the APSC, accepts notice on behalf of respondent numbers 3, 4, and 5. Issuance of formal notice is dispensed with. First of however, requisite extra copies of the writ petition will be served on them in course of the day. Next one, list on so and so.
31/5. Item 6.
Matter relating to compassionate family pension. And petitioner father.
Just a moment. Where is the document to show that she has gone away and married the wife?
Yes, Lordship.
Where is the document?
I have photograph also. Page 26, Lordship.
26. Okay, we are issuing notice then.
Notice.
Heard Mr.
Yeah, Ali.
A. Ali Loan Counsel for the petitioner. For the petitioners. As well as Mr. D.P. Baral and standing counsel for the health department appearing for respondent numbers 1,
2, 3 and 4.
2, 3 and 4. For accountant general, the other option, Mr. B. Chakravarti, learned standing counsel, accept notice for respondent number 5.
I am for 6.
Mr. B. Chakravarti, learned standing counsel for respondent number 5, comma. Mr. T.C. Chudial, learned additional senior government advocate for respondent numbers 6. And treasury officer, you are there.
Treasury
Ms.
officer.
Anand Das, learned standing counsel for the finance department appearing for respondent number 7. But your petition, it can't be allowed, even we can't issue a notice. Look at the name of respondent number 8.
Yes. This is her mother at this, mother home address.
You are writing wife of so and so, and you are making statements as something else.
But
You correct it.
it's left Dilis Baspar, but presently he's also Baspar wife, the new
Then
husband.
he can't be the wife of late so and so. They can't be wife of two persons.
Only one.
Yes.
You make corrections in the cost title.
Yes.
Are present. It is noticed that contrary to the statement made in the petition, the cost title of in respect of respondent number 8 discloses the respondent number 8 to be the wife of late Dilip Basfor. According to the counsel for the petitioner, praise for him is permitted to make necessary correction in the cost title by furnishing an amended cost title to the AOJ civil pending section. On receipt of the same, the central registry shall be corrected and thereafter the matter be listed in the motion column.
Item 7.
Obliged.
Yes, Mr. Rabha.
This is a method of appointment in a municipality board. Municipality board. So here, you see, this petitioner was also aspiring for the job. When he asked the municipality, he responded that there is no any post. But after few days, he came to know that one master role employee has been appointed in the regular post of LDA. That post was not advertised at all. Being deprived because he was aspiring.
Okay, we are issuing notice. But Mr. U.C. Raval, counsel for the petitioner, and Mr. A. Chakravarti, learned government advocate appearing for all the respondents.
No, Lordship, 1 and 2,
So
Lordship.
1 and 2.
1 and 2.
1 and 2.
Lordship, appointment was issued by Satyabari Municipal Board, Lordship.
Okay, okay. Given that the respondent of 5 was illegally appointed by the Satyabari Municipal Board, the present petition has been filed under Article 226 of the Constitution of India, and I think that by illegal appointment, the petitioner has lost a scope for offering his candidature. Next, we shall notice returnable on so and so after 5 weeks.
28-6.
Requisite extra copies of the petition be served on the government advocate for respondent numbers 1 and 2. The petition shall take steps within 2 days for service of notice on respondent number 3 to 5 by registered post with AD The counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Next one, the appointment of respondent number 5 shall be subject to further order within bracket S that may be passed by this court.
Item 8.
Yeah, leave it. That's
Yes,
it, the
Mr.
petitioner, my
Dingia.
lord, approves, my lord, the Victoria, my lord, approve, my lord, the withdraw, my lord, the benefits of retention, my lord, the GOP accommodation, my lord. My lord, the petitioner, my lord,
Okay,
here.
we're issuing a notice.
Yes.
Okay. Heard Mr. Alan Dingia and counsel for the petitioner and Ms. R. Devi and CGC appearing for the respondents. The retention charges to the extent of rupees 5,26,891.47 of the quarter of the petitioner is held in this resolution filed under Article 226 of the Constitution of India. Leaving that the withholding of the quarter is permissible under OM dated 6/10/2022. Issue notice, including notice on the period for interim relief returnable on 5 weeks. On so and so. Requisite extra copies of the reparation be served on the CGC in course of the day. Next paragraph. They have recovered money from you know.
No, no, yet, my lord, but at apprehend, my lord, already, my lord, the in website, my lord, already, my lord, is calculated, my lord, each some part are calculated. The website, my lord. It is, my lord,
Till the,
page 150.
as an interim measure. Until the next returnable date is provided that if the recovery has not yet been made by the respondents as on 15/5/2024, or this recovery shall not be made till the next returnable date. Next, the petitioner shall produce a certified copy of the order before the competent respondent authorities. List on
28/6.
Oh, bless.
Master bill.
Item 9.
you have to file a civil suit and recover money from person who has appointed you.
Actually, my case is slightly different, Lordship. I'm just praying for a consideration of this appointment application, which is filed by the petitioner before the respondent. Because similarly situated persons file application and they were,
No, that's not
Consider-
permissible. It will be contrary to Article 14.
Lordship.
You have to dismiss your reputation. This can't be promoted.
Lordship. My limited prayer is that, Lordship, on next board of directors, if they can
That can't
consider,
be permitted.
Lordship.
That will be contrary to Article 14.
Because I was engaged with the other candidates and I was terminated, they remained in their applications were considered on the second board of directors.
No, then you challenge their appointment. You will be gladly interfering.
Since I'm a casual employee, I'm not challenging
No,
their.
this is not permissible.
Lordship, I'm a very poor lady. In fact, the husband of the petitioner, he cannot work after 2020 because he met with an accident. Lordship may kindly be considerate. Let them take a decision, Lordship.
No,
If they can consider my application, this is
No.
just a matter of casual employment. Lordship.
they would have done it by
Lordship.
now. Heard Mr. R. Bora,
Lordship.
learned counsel for the petitioner, and Miss Tushi Singla, learned counsel for the respondent. Next one. The case of the petitioner is that she belongs to scheduled caste community and hails from a extremely poor financial background. Full stop. She had submitted an application before the managing director, Assam State Development Corporation for Scheduled Castes Limited from Assam on 22/2/2020 to engage her as a peon. Full stop. Accordingly, the petitioner along with others were appointed as casual laborers. Full stop. However, on 1/8/2021, the service of the petitioner was discontinued. Full stop. Her representations before various authorities, including the respondent, did not yield any result. And therefore, this writ petition has been filed under Article 226 of the Constitution of India with a prayer to direct the respondent authorities to consider her representation for being engaged as a casual labor. Next, the learned counsel for the petitioner has submitted that although the service of the petitioner was discontinued, but engagement of several other persons as casual labor are being continued. Next paragraph. The court is unable to give its seal of approval to the appointment of persons even as a casual labor on the basis of representation, which is contrary to the principle of public employment and is hid by Article 14, and such procedure is hid by Article 14 of the Constitution of India, as others who may be requiring the job and are having requisite qualification are deprived of applying for the job. Therefore, notwithstanding that the respondent has illegally appointed others, but in such matters, the right to negative equality cannot be pressed. Therefore, as the manner in which the petitioner is seeking employment is contrary to the public policy, this petition cannot be entertained, and accordingly the same is dismissed. Next, if the allegations made by the petitioner is correct, that the respondent has engaged other casual laborers without following due process of public employment, the court records its deprecation. Court strongly deprecates this manner of employment. The petition is dismissed.
But you may kindly give liberty to file an application before them.
No.
If possible. Obviously.
What is your age now?
42 years. 42 years.
42.
Yes, Rakshit.
Then you can't even be considered.
Rakshit, 1 year is still there, Rakshit. She belongs to OBC category. 43 years is the highest. But
If the respondents carry out, what do you call, make an advertisement, inviting applications,
Rakshit,
in such an event, taking note of the previous service rendered by the petitioner, the respondent authorities shall consider an application for confirmation of age, if permissible, in law.
published. Much obliged.
Yes, Mr. Chaudhary.
Item 10.
Says I'm praying for a notice, my lord. Yes. And secondly, my lord, in case they decide to fill up the post, that will be subject to the outcome.
Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. R. M. Dekal and counsel for the petitioners. Also heard Ms. R. M. Das, Learned Standing Counsel for the Finance Department.
I am Bara, your lordship.
R. M. Bora, I'm sorry. I always make a mistake. Growing old. I don't know why, Mr. Chaudhary, but these names I find it very difficult to remember. Every day I have to search for names and then I forget.
Same problem with me also, madam. Half
But
of
it
the
shouldn't
time
happen.
I,
It shouldn't happen. They are regularly appearing.
in this regard, I found A.K. Goswami was very, I mean, he used to remember each and every name.
Yes, that's an old saying. All work and no play makes Jack a dull boy. So our what do you call absolute engrossment in work.
Sometimes happens.
I'm sorry, but when saying this for the finance department, representing respondent numbers 1 and 2.
1 and 2.
This 3 does not have a standing counsel. No. Okay.
It's served notice.
Huh. The discontinuation of the service of the petitioners is under challenge and under challenge by filing this writ petition under Article 226 of the Constitution of India. So the petitioners claim that since they've been appointed pursuant to advertisement dated, employment advertisement dated 3/3/2017, they cannot be termed as a contractual worker. Accordingly, the next paragraph, issue notice, including notice on the period for interim relief is available on give a date, same date, 28/6, 2024. Requisite extra copies of the writ petition is served on the departmental counsel in course of the day. Next paragraph. The petitioners shall take steps within 2 days for service of notice on the respondent number 3 by registered post with AD, as well as by the SNI, by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. Pending disposal of this writ petition, it is provided that if any engagement is made, in the posts which were in which the petitioners were engaged, comma, the same shall be subject to further order within bracket S that may be passed in this replacement.
Diploma.
Item 12.
Made physiology.
Just a moment.
Dismissal or
Just
again,
a moment.
dismissal matter notice based.
Just a moment. But Mr. T. Deorin, counsel for the petitioner. The dismissal of the petitioner in the department proceedings and the rejection of appeal are under challenge in this writ petition filed under Article 226 of the Constitution of India. Issue notice returnable on same date, 28/6/2024. Next paragraph. Mr. T. Sutyal, an additional senior government advocate, accepts notice on behalf of respondent numbers 1, 2, and 3. Poster. Accordingly, extra copies of the writ petition will be served on him within 2 days. Next paragraph, the petitioner shall take steps within 2 days for service of notice on respondent number 4 by registered post with the next part, the current counsel for the petitioner is permitted to collect the postal track report and postal receipt number and submit postal track report prior to the next date of listing. List of instances.
Deprivileged.
You'll be, is records required? No. I think you'll have everything.
Yes, sir. Deprivileged.
13.
Yes, Mr. Goswami.
Have filed an appeal before the Director of Land Records, selling the selection and appointment of the private respondent to post of Gambura in March
Oh,
2000.
they have appointed someone.
Lordship,
They have appointed someone.
Lordship. We have filed an application for urgent hearing of the matter. They have not taken the matter. Single matter has not been taken by the Director of Land Records till date, Lordship.
I understand. This is from which place? Nalbari.
Nobody, Lordship.
Okay. But Mr.
In
SK.
similar situation, we have filed a petition and this court has directed to dispose this matter within 2 months. Lordship will kindly see
No,
page 44.
We can't give a date because we don't know. There's a everywhere in all the districts. So the
As per
appeals
my
are
information-
pending before the.
As per my information, 66 cases has been filed, not a single case has been taken.
No, I know that. We are aware of it. So therefore, to give a date will be again ineffective. Let us give a notice. Let them say. Let them say. Mr. SK was counsel for the petitioner. The appeal number 27 of 2024 filed by the petitioner is pending for adjudication before the Director of Land Records
And survey.
and Survey, Assam. Appeal number so under section 162, dash capital C of the Assam Land Revenue Regulation. So, next, the learned counsel for the petitioner has submitted that as per his instructions, many appeals are pending for adjudication before the said authority. Which is which has the effect of frustrating the appeal filed by the petitioner. Issue notice returnable on same date.
28/6.
So
We have also filed an application for urgent hearing also. That is also not taken, Lord Sir.
not that. Ms. A. Chakravarti, government advocate accepts notice.
4 and 5.
Revenue will be you.
1 and 5.
Mr. S. Datta, standing counsel for revenue department accepts notice for respondent
1 and
1 and 2.
2.
And
3 and 3, 4 and 5.
And Mr. A. Chakravarti, government advocate accepts notice on behalf of respondents 3, 4 and 5. First, requisite extra copies of the petition be served on them within 2 days. Extra, the petitioner shall take steps within 2 days for service of notice on respondent number 6 by registered post with AD. Post of the learned counsel for the petitioner is at liberty to, they shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next para. Having taken note of the submission made by the learned counsel for the petitioner that even an application for urgent hearing has not been taken up by the said authority, the court is inclined to provide that the pendency of this writ petition shall not be a bar for the Director of Land Records to take up the application filed by the petitioner for an early hearing. Next para. Having noted that several writ petitions have been filed before this court with the same allegations that the Director of Land Records and Survey is not adjudicating any appeal filed under section 162-C, the court is inclined to issue notice to the Chief Secretary to the Government of Assam to bring this state of affairs to his notice. Next para. The what do you call it? Chief Secretary as well as to the not so and so. Next para. We also expect the Secretary to the Government of Assam, Revenue Department, within bracket, respondent number 1, to also look into the matter and take remedial steps. Next para. The learned government advocate shall send a downloaded copy of this order to the Chief Secretary to the Chief Secretary of the Government of Assam to bring this to his notice. First off, similarly, the learned standing counsel for the Revenue Department shall also transmit a downloaded copy of this order to the respondent number 1 to bring it to his notice. Next one, based on so and so.
May I say one thing also? Appointment may be subject to the appeal, subject to the order passed by the appeal also.
No, that they will definitely pass.
That will benefit me also because I am not taking any interim order. That is why.
No, because if I am not adjudicating, I can't pass an interim order. That's why. On that principle only. But let us see with this order, I think something will happen.
In earlier occasion, this court has passed interim order.
No, that's okay. But
understand.
Mrs. Goswami, you are a season.
Understand my point. I have to face my client. That is
it's okay. Just add there. Liberty is granted to the learned counsel for the petitioner to press for the prayer for interim relief on the next date. Okay. I understand. With that last submission, I now understand.
Instead of section, executive instruction.
Huh?
Instead of section, it is executive instruction on 62C.
Oh, executive instructions. Executive instructions under the Assam Random Review Resolution 1886. Okay, right. Thank you.
14.
it out.
Lordship, this is pertains to the selection and appointment of Anganwadi worker. Lord, as pursuant to the advertisement, my lord, the petitioner applied for the post of Anganwadi worker and being eligible, my lord, he participated in the selection process.
No, but if the same post is being re-advertised, you are getting one more opportunity of contesting.
Lordship, petitioner lodged the complaint, Lordship.
Yes.
Petitioner lodged the complaint, Lordship.
Yes,
After inquiry, Lordship, it was found and he issued a re-advertisement, Lordship.
Yes, my lord. But, my lord, on the basis of my complaint, my lord, inquiry was conducted and through my lord, White,
No, but,
impugned.
no, you see, Mr. Mazumdar, notwithstanding the fact that you have challenged that the new advertisement, and it is on your complaint that the appointment was set aside. But you see, it's a legal principle that once the appointment is made, the selection process ends. So in the selection process which has ended, you can't issue a direction for your appointment.
No, my lord, I am just, my lord, paying for, my lord, who participated in the selection, my lord. Among them, my lord, the appointment should have been made, my lord. But instead of that, my lord, the authority issued direction to re-advertise the post, my lord.
No, it has to be
That's-
re-advertised.
But,
Because you
my
can't
lord,
have
in the
a,
meantime, my lord, I've come to know, my lord, that there is respondent 5, my lord. He also referred a petition, my lord, by WBC 2162, my lord.
Yes,
Yes, I
that.
have a copy of that, my lord. This, in that case, my lord, issue notice, my lord.
Okay. Mr. Mr. K.I. Mazumdar, counsel for the petitioner. The notice including notice on the prayer for interim relief, returnable in 4 weeks. Mr. A. Chakravarti, Land Government Advocate, accepts notice on behalf of
1 to 4, Lordship.
respondent numbers 1 to 4. Next, the petitioner shall take steps for service of notice on the respondent of 5 by the registered post with AD. Even 2 days, steps within 2 days for service of notice on by registered post with AD. On the next date, the counsel for the petitioner shall also make his submission as to whether by appointment made pursuant to advertisement dated 10/1/2023, the previous process of recruitment has come to an end. Next, list after 4 weeks.
May come with this matter, my lord. Tag, my
No, we are not tagging it. You serve notice on respondent number 5 first.
lord.
Item 17.
As per this direction of this honorable court, I have already filed an impeachment petition in Lordship.
Okay. We're issuing notice then? Okay. But Mr.
D. Mormon Lordship.
D.
Bormon.
Burman, done counsel for the petitioner. Issue notice including notice on the prayer for interim relief returnable in 4 weeks. We'll give a date after. Say
Four.
the date 28/6.
26.
28/6/2024. Miss
Eight Talukdar, Lordship. Eight Talukdar for
A-
respondent number 3.
Miss A. Talukdar, Leonard. Department Council accepts notice for respondent numbers
3. 3 and 4, Lordship.
number 3 and you are government advocate?
Lordship.
Okay, government advocate for respondent numbers 3 and 4. And Mr. A. Fukan, Leonard, Departmental Council accepts notice for respondent numbers 1. Who's for 2? Okay, you. Okay, Miss, you write your name because I always forget. Land Council, it is on behalf of Mr. Ardhar, standing counsel for the respondent number 2. Requisite extra copies of the petition be served on them within 2 days. Next one, petition shall take steps for service of steps within 2 days for service of notice on respondent numbers 5 and 6 by registered post with AD. List on Swenson.
Obliged, Lordship.
Send it.
Item 19.
Reading is complete.
On the last occasion, my lord, the respondent sought for time to produce the records of the recruitment proceeding.
Just now. Yes, Mr. Dhar is not there.
I think, my lord, I have seen a letter, my lord. I have sent it for confirmation to Dhar. They have sending the record, my lord. I think
Okay, after some time.
after some time, my lord.
Ardhar. Standing counsel.
Twenty.
In this case, my lord, they have sought time on the last occasion, my lord, to file the affidavit in opposition, my lord. The matter was last listed on 24th of April, my lord. And since then, they have
Where is that document? Challenge document? Where is the impugned document?
the order, my lord, impugned order is a page. The WT message, my lord,
Where is that page?
page 77, my lord.
Then you should have filed a contempt.
No, I was not the party in the earlier proceeding.
No, you see, because it can't happen. You'll have to either file an application for modification or something. Here, what has happened that this court had directed that a review DPC be made. So therefore, the original record be returned back. It will be considered only by a review DPC. Yes, what is your instruction? Review DPC being held?
My instruction is a draft affidavit is ready, my lord. We have sent a letter for swearing in on 6 May 2024.
So what has happened to the implementation of the earlier order of this court?
Earlier order.
That is at page 68. It starts from 67. Order is at page 68. You see, this court had set aside the earlier recommendations and they said that a review DPC be made. That is at page 76.
The BTC is there, my lord. We are only responsible for only, my lord.
But this order has to be
Six.
complied with.
Six.
They can't, they could not have sent back all the documents. It had to be sent to the, it had to be sent to the DPC.
Yes. Golden is there, responsible 2. And otherwise, my lord, 3, 4, 5, 6, and 7, we are appearing. My lord, only I have, in this file, my lord, only draft affidavit is there, my lord.
No,
Sometime may be granted, my lord, so in the meantime, I would.
No, but did you take take this aspect into consideration while drafting the draft affidavit? Did you deal with this issue?
No, draft affidavit.
That's the main issue.
Honorable Court reviewed the order that however, a review petition was dismissed by Honorable Court on order non-government. Now the government has decided to prepare a second appeal in case and accordingly has initiated the necessary process. Since the instant case is similar in nature, there with Atikur Rahman, State of Assam governed by the same rules and
Once you do that, you will be in contempt.
Assam supply in the department, it is appeared to wait till a final verdict of the passed by Honorable Court.
So once you thank your stars that if the affidavit had been filed, we would have taken so much of contempt.
Well, let me have an inquiry. In fact, I don't have the petition also. Only few papers are there. One letters and a draft affidavit. Let me have interest on Friday, I will inquire the matter on this thing.
You take it up next Monday.
Next Monday, Sandeep, Deputy.
But Mr. S. counsel for the petitioners on the prayer made by Mr. T. Sutyar, an additional senior government advocate. Matter stands adjourned today. List on 2/05/2024. The interim order passed today stands extended till the next date of listing. We'll just add something in the order so that you can have it.
I will check it. I will check it.
This one so as to enable the state council to inform this court about the status of compliance of judgment and order dated 31/3/2022 passed in WBC 5158 of 2021 whereby a review DPC was ordered. Distance transfer.
Twenty-one.
Maybe lordship. Maybe this lordship. Lordship, kindly pass over for time being lordship.
Just a moment. Who's appearing for the CGC? You are appearing?
Well,
You have instructions to the matter?
but as per my instruction, it is reflected in earlier order dated 26/6/2023.
Yes.
In terms of the order, he is not qualified because he has lack of that, my lord. He has not fulfilled the criteria as mentioned in the advertisement itself, my lord. Whatever his contention is that his height was 169 centimeter. In fact,
Yes.
my lord, as per the norms, he is required to be fulfilled at 171 or so, only. 171 centimeters. So he has not fulfilled that criteria. That is why he is not eligible for the post. The relaxation clause is not applicable in respect of petitioner's case because it is applicable only in case of the compensation appointment.
Okay. Now, on the prayer made by Learned Counsel for the petitioner, the matter stands adjourned today. Mr. UK Goswami, Learned CGC is present. List after 2 weeks.
I prefer time being lordship. Some after time lordship. Be
Oh,
senior
after some time.
after some
Oh,
time.
okay. Okay, we'll take it up
That
after
will
some time.
be in another day. So that,
We'll take it up, there's small issues.
Just something lordship. Mr. B senior is on.
Oh,
Come at 2 o'clock.
at 2.
At 2. Okay.
22.
At 2 then.
Great, please, Your Lordship. We have received our instruction. We'll be filing affidavit in 2 weeks, Lordship.
It is since last 3 months, they are submitting the same thing. We have received the
You file a
instruction.
money suit for recovery of compensation if they are delayed. You see,
No,
don't
no,
make those.
no,
kind of-
my issue is that lordship, the petitioner is.
Please
severely
understand,
ill.
these things, there are some delay, but they are now saying that they are ready with the instructions. What can we do?
But my petitioner is severely ill, lordship. That is why I'm submitting. He is almost bedridden.
You notice submission and don't adjourn. File it within 2 weeks. Right. Both sides are duly represented. Mr.
I bought her
I. Bhattakul, and standing counsel for the
all the respondents.
respondents. Undertakes to file affidavit in opposition within 2 weeks. It is made clear that if affidavit in opposition is not filed, the court may proceed to hear the matter on the basis of materials available on record. List on, after 2 weeks, give a date.
31/5. '23.
May I please, Lordship, instruction received, Lordship, will file affidavit within 2 weeks, Lordship.
Okay. Both sides are represented. Attorney Chakravarti and government advocate. Respondent is granted 2 weeks time to file affidavit in opposition in the matter. List on,
31/5.
Obliged, Lordship.
or make it 3 weeks. 2 weeks of time, they say.
10/6. 24.
Lordship, may I please, your Lordship? Lordship, in this matter, Lordship, we need some more time. We have received a
just now.
communication from the department, Lordship, and it says that due to the general election, Lordship, it's facing some difficulty in submitting the comments on time, Lordship.
My lord, I was placed under suspension on 5/4/2023. And my lord, as per order dated 9/4/2024, they are directed to take instruction whether my suspension order has been reviewed or not. What happened, my lord? I was arrested, my lord. Pursuant thereto, I was placed under deemed suspension. So cause notice was issued. I submitted my reply. And when the disciplinary proceeding is in process, they issued the impugn order in reference to earlier so cause notice, my lord. And till date, the suspension order has not been revised, my lord. So today, my pay is to my lord.
No, this is not what is required. If this is a case of suspension, you have to only show that
And they have already filed an affidavit, my lord.
There also they have not mentioned that.
No, yes.
You'll have to tell your district commissioner, this will not be a ground. The only reason is whether they have extended it or not. As per the, so we are taking it next week.
Yeah, sure.
Both sides are represented. Miss
A. Talukdar.
A. Talukdar and government advocate has produced a copy of letter dated 10/5/2024, seeking some more time to by which the district commissioner Silchar has sought for some more time to provide instructions due to the ongoing general election activities. Next paragraph. The first for the timing, the only instructions that is required is as to whether the order of suspension of the petitioner has been reviewed.
Yes.
And if so, comma, copy copy of such order be provided to the court. As the law laid down in respect of continuous suspension is well settled, comma. The court is inclined to grant 7 days time to the District Commissioner Kachar Silchar to inform the court about order, comma, if any passed for reviewing the order of suspension and to provide a copy of such order. This document. 22/5/2024.
Lordship.
That is the only thing we require.
Lordship.
The letter dated 10/5/2024 is returned to the government affiliate. You are also there?
My lord, the next date fixed, my lord, kindly my reinstatement can be considered, my lord, the next date, my lord.
We are aware of it.
My lord.
Which is the corresponding number?
1 and 2.
1 and 2 is present.
And deeply obliged.
Deeply obliged.
Item 25.
Dismissal from service, my lord. No, we have received instruction, my lord, we will file affidavit, my lord. After motion, today's second time, I still listed.
Okay. Records will not be necessary.
I think, my lord, after filing the affidavit, my lord, the record may not be required.
Okay. Both sides are represented. Mr. T. Sudhir, an additional senior government advocate, submits that he has received instructions and would be filing affidavit in opposition within
Within, my lord, 2 weeks, my lord.
within 2 weeks.
2 weeks. Superintendent Bongaon.
Matters done today based on 2 weeks will be we are listing it on 31/5.
Yes, my lord.
Obliged.
Obliged.
26.
My lord, would kindly come to the last order.
Yes.
Whereby notice was issued on 19th of January 2024. It was observed that the division bench's judgment in Upendra's, my lord. So we were entitled to the benefits of minimum pay scale.
My lord, affidavit is ready, my lord. Draft affidavit is ready. I have sent a letter for swearing in, my lord.
Let it be filed, my lord. It would be better
yes.
this time, since there were earlier litigations also.
Yes, after 2 weeks, my lord.
Okay. Both sides are represented. So, government advocate, please for same order, same date. Just make it clear. The 31, make it the 3rd June. My lord. Oh, bless. 3rd June is both will go. 31st of both the 36. 27. Yes, you have instructions?
BTC.
For BTC is appearing?
BTC lots. I'm appearing on only last one or one lots.
No, BTC here it is required.
BTC is the main lots.
SCBTC. SCBTC for item number
27.
Just wait for some time.
Item 28.
Very please, your lord. Just
My lord, right impugn order dated 17/7/2020.
Just a moment.
Lordship, we have received instruction, Lordship.
Is by when you'll file your affidavit?
Lordship, kindly when, 10 days time, Lordship.
Both sides are represented. Ms. A. Talukdar and the government advocate submits that she has received instruction and will be filing affidavit in opposition of the matter within 2 weeks, based on 3/6/2024.
Keep your best, Lordship.
Deeply obliged.
Item 29 with 30.
My lord, I am appearing in item number 30, my lord, and today we have filed reply against the affidavit opposition filed by the respondent number 5. Today we have filed our reply.
You filed your reply.
Yes, ma'am.
We'll take it up next week then.
Your Lordship, in item number 29, Your Lordship, there was an order wherein, Your Lordship, there was an amendment to the cost title and paragraphs. Your Lordship, we have made that correction, but however, subsequently, Your Lordship, there was a particular error on our part in respect of serving the amended petition to the respondents. Therefore, in that matter, Your Lordship, no affidavit has been filed because of late submission of the petition, amended petition, Your Lordship. So,
Sometime maybe granted.
Okay. That is in, your case is 284.
yes, Your Lordship.
Okay.
It would have
Mr. D.S. Dekar and counsel for the petitioner
34.
submits that due to inadvertence, the copy of amended petition could not be served on the respondents. The same shall be done within.
Your Lordship, we have served them, but at a later period of time. Your
Okay.
Lordship.
The inadvertence, there was some delay
Yes, Your Lordship.
in furnishing the amended petition to the government advocate. Next, Mr. T.C. Sridhar, additional senior government advocate, prays for his contact. 2 weeks time. 2 weeks time to file affidavit in opposition in the matter. In next item 331. D.K. Roy, counsel for the petitioner, is present and submits that affidavit reply has been filed today,
Yes, ma'am.
which is first off, the registration tag is saying in record. Mr. T.C. Sridhar, an additional senior government advocate, is present. List on 3/6/2024.
Time being item 27.
Yes, Mr. Nahar.
Lordship, in this case, Lordship, I have already received instruction. If Lordship grants me 2 weeks time, Lordship, it have been intervened, file my affidavit.
Okay. Okay, both sides are represented. You say all sides are represented. Mr. P. Nayak, and the stand counsel for the BTC has submitted that he has received instructions that will be filing affidavit in opposition within 2 weeks. Next matter stands adjourned today, based on 3/6/2024.
Lordship.
31.
Lordship, the matter may be possible for time being.
Lordship, instruction received, Lordship, we'll file affidavit, Lordship.
This, what is your instructions? Please pass it on. What is the representing? Mr. A. Chakravarti, known government advocate, submits that he has received uh, instructions and would be filing affidavit in opposition within
3 weeks, not.
3 weeks. Questions is on today based on the date after 3 weeks.
Ten six.
Obviously.
Item 32.
But affidavit is today, the person is coming, my lord, to swear. in. Ready.
You're filing it today.
Yes, today, he inform us. He's coming, my lord.
My lord, as per the last order, 5424, my lord, there was a direction for paper publication, my lord. And I have filed an affidavit with that regard. my lord. Paper publication,
The activity is not here.
look, affidavit.
Paper publication কোনে কৰিব? তোমালোকে। Additional affidavit দিছা? Paper- আৰু public কৰা নাই নেকি?
Mr. K. Vishwakarma, and counsel for the petitioner submits that an affidavit of newspaper publication or notice was has been filed after publishing along with the this is the one.
Yes, my lord.
এটা কপি আমাক দিবাচোন যে। আপোনাৰ paper one.
Along with the original newspaper.
My lord, page number 103.
If you have not taken steps by registered post with AD,
My lord, that registered post with OD, it was not directed, my lord. It was said that.
no, you see there, we have our own reservations. Mr. Vishwakarma,
Yes, ma'am. My lord, actually, the respondents, we were unaware about the address. That is why on the last occasion, when the matter was listed, the honorable court found that paper publication should be made by us.
no, but you see, these people are home guard.
Yes, lord, sir.
Unfortunately, in my, for my security purpose, there are home guards appointed.
Yes, sir.
I've never seen them reading newspapers.
But,
You see, it's not that the man will not, newspaper is an excuse. But you, if a notice is not sent by registered post with AD, You see, what is the law requiring the substituted service? Order 5 to 20 says that if they are avoiding service, now the steps have not even been taken. That's number one. But their appointments, nobody will know where their residents are. You please find out from this, from the commandant of Home Guards, how they will be serving notice to these people, these Home Guards.
By registered post, my lord.
No. Their addresses are not known.
Oh, address
See,
is not known, my lord.
Home Guard is appointed, he is posted anywhere for a limited period. So therefore, they are rotated. Here, what has happened? He's asking for seniority, therefore he is required to make those people party.
Parties.
Now these people will have to be informed about this case. So either the commandant of Home Guard will have to issue a general notice to this 20
Other person, my lord.
to the other persons, because they have to be notified.
My lord, they have published the paper public.
No, I understand, but you see, I know of people who are with me. I have never seen them reading a newspaper, therefore,
Newspaper, my lord. My lord,
and if supposing we allow the retribution today, tomorrow somebody will come and say that I have not been heard.
Yes,
I have
yes,
given
definitely.
opportunity to be heard. So we are multiplying cases, in fact.
My lord, let him send me a copy of the paper publishing, my lord. I will send it to the, my lord, commandant.
Because it is, you see,
They are
order
made with
5 to 20
adequate,
for substituted service.
no?
Yes, sir. I know the difficulties.
Yes, sir.
I read, I am provided with newspapers daily. But I don't remember in my life, I have read a newspaper to find out if there is any court case pending against me. So once I refuse service, avoiding service, then there is a presumption because of the fact that
Deemed to be service.
post has gone to my residence and I'm avoiding it. So therefore, then there is a presumption of substituted service under Order 5 to 20. I don't find this is an acceptable mode. Mr. K, has
Moving
a
the copy,
negativity of, along with the newspaper. Let a copy of thereof be provided to Mr. T.C. Jyotial under additional
I'm
senior company
providing it
advocate.
right now.
Next point. The next point, the court notes that the court takes notice of the fact that in respect of the newly imputed respondent numbers 4 to 27, their addresses are not known to the petitioner, and therefore they've been arrayed as respondents with the address of the Office of the Director General of Civil Defense and Commandant General of Home Guards of the Gujarat. Therefore, the learned additional senior government advocate is requested to inform the respondent number 3, i.e. Director General of Civil Defense and Commandant General of Home Guards Assam, to make an endeavor to inform the respondent numbers 4 to 27 about the pendency of this petition. The next of the listing is fixed on 7/6/2024, which will be specifically communicated to this, the respondent numbers 4 to 27. Full stop. The respondent three shall provide appropriate instructions to the learned additional senior government advocate regarding service of notice on the respondent numbers 4 to 27, informing them about the pendency of this rate petition, which is scheduled to be listed on 7/6/2024. Next one, list on 7/6/2024.
Or that amended cost title has been also annexed
I think
here.
you've seen that.
I oblige.
I'll take a break and come back.
My learned engaged council is engaged on contract code. Kindly keep for the time.
Just a moment. Yes, you're not filing affidavit.
My lord, as far as the annexures are concerned, my lord, his grievance is that he is not allowed to resume services post the fact that he got a bail, my lord, from this honorable court. And he has filed a representation, my lord, to the CEO, which is at page 31.
Yes.
And the CEO has thereafter forwarded his grievance to the commissioner, which is at page 34, my lord.
Yes.
So, well, this writ petition may be disposed of with a direction to the commissioner to dispose of this writ petition within a period of say 30 days. That will redress his grievance. The fact-finding inquiry, my lord, which he has to basically initiate.
No, you see. You have to before making that prayer, you have to show us that he is not being given work because of the orders passed by the commissioner. Otherwise, every Tom, Dick and Harry will say that I am not passing an order, I am referring it to commissioner, please write orders.
Malad, there's a provision, section 137 of the Panchayat Act.
Panchayat Act.
I'm probably
137.
137.
Yes.
Video.
Video as well. Chief executive.
Okay. Lord, 137 says, appeal against any order of the Panchayati Raj institution, any employee under a Panchayati institution or person aggrieved by any order or act. Act is also included, my lord, of a Panchayat institution may file an appeal within 15
No, he
days.
has not filed an appeal. He has gone to the CEO to give him work. Now,
No, my lord.
CEO says that I am not passing an order, he will file an appeal.
No, my lord. He has not filed an appeal.
No,
CEO has forwarded.
petitioner is not filing an appeal. He has sent a representation to the CEO that please give me work. Now your officer writes to the commissioner. That means your officer is filing an appeal.
Forwarded it to, yes, my lord.
Correct.
Yes.
So we'll ask the commissioner to suspend your CEO. Can he do it? You see, it's very simple. I get a writ petition. I don't understand the writ petition. I said that let the division bench pass an order. Can I do it? Then, if your officers are unworthy, you remove those officers. If CEO does not know how to pass an order, he's not fit to be there. He let everything to commissioner and commissioner will do all the work.
My lord, in that case, let the CEO pass.
No,
on.
we'll ask the commissioner to be here. Because if that is how he is running the department, allowing any Tom, Dick and Harry to write to him to pass orders, then remove the CEO. How could you make that argument as a departmental council? It was an unworthy argument you have made. This was not never expected. The departmental council will say that, okay, my commissioner will pass all orders. The CEO is there for nothing. He's ornamental. CEO could not have filed an appeal. We direct the CEO to pass an order within 10 days.
That would suffice, my lord.
And in writing, he'll seek an apology to the commissioner for forwarding it to him for pass an order
As my lord deems fit.
within 10 days. he'll
Within
do
10
it.
days.
This man should know that there's something which requires a work culture. But Mr. M. Segar and counsel for the petitioner. Mr.
P. Handick, my lord.
P. Handick Leonard,
Counsel
standing
for
counsel for
PNRD.
the PNRD department, has submitted that the Chief Executive Officer, Lakhimpur Zilla Parishad, North Lakhimpur, on receipt of representation from the petitioner dated 2/11/2023 from the petitioner to grant him permission to resume his service, the same has been forwarded by the CEO, Lakhimpur Zilla Parishad, to the commissioner. Where is that?
Page 34, my lord.
It's what the same.
Representation that 31 and XIA.
Huh? To the Commissioner, Panchayat and Rural Development Department. By a forwarding letter dated 3/11/2023. Accordingly, the learned standing counsel for the PNRD has submitted that the writ petition can be disposed of with a direction to the Commissioner, PNRD to dispose of the representation dated 2/11/2023 passed, submitted by the petitioner. Next paragraph. In this regard, the learned departmental counsel has referred to the provisions of section 137 of the Assam Panchayat Act, 1994, which provides for appeal against any order of the Panchayat Raj institution. Next paragraph. In this regard, the court is of the considered opinion that as the petitioner has submitted a representation to the Chief Executive Officer, Lakhimpur Zilla Parishad, North Lakhimpur, a duty is cast on him to pass an appropriate order to stop. The Chief Executive Officer, Lakhimpur Zilla Parishad, cannot be permitted to shirk his duty and to refer it to the Commissioner, PNRD department to pass an orders Full stop. If he does not know how to pass an order, comma, it would be the Commissioner and Secretary to the Government of Assam, PNRD department to take a call if unworthy people are allowed to remain as CEO of the Lakhimpur Zilla Parishad. Full stop. Therefore, next paragraph, therefore, comma, instead of directing the Commissioner and Secretary to the Government of Assam, comma, PNRD department to dispose of the representation dated 2/11/2023, comma, the court issues a direction on the Chief Executive Officer, comma, Lakhimpur Zilla Parishad to number 1, dispose of the representation of the representation dated 2/11/2023 submitted by the petitioner within 10 working days, during which the commissioner, the Government of Assam, PNRD department shall take cognizance of his inefficiency to work and pass appropriate orders. Number 2, the Commissioner Secretary to the just full stop, only one. Next one, the Commissioner to the Government of Assam, PNRD department shall follow up this order to ensure that the Chief Executive Officer, Lakhimpur Zilla Parishad, disposal of the representation dated 2/11/2023 passed by the submitted by the petitioner by an appropriate order. Next paragraph. The strong exception to the Chief Executive Officer, Lakhimpur Zilla Parishad, shirking of his duty has invited the displeasure of this court because of the fact that the said authority cannot be said to be an aggrieved person so as to file an appeal. So as to treat the representation dated 2/11/2023 submitted by the petitioner as an appeal and forward it to the Commissioner to the Government of Assam, PNRD department. First of this exposes his inefficiency in handling the matter. Next paragraph. List on after 2 weeks due date. Next for the standing counsel for the PNRD department shall transmit a copy of this order, download a copy of this order to the Commissioner, Panchayat and Rural Development Department, Government of Assam, as well as to the Chief Executive Officer, Lakhimpur Zilla Parishad. Next paragraph. The Chief Executive Officer, Lakhimpur Zilla Parishad shall ensure that the compliance of the order is communicated to his departmental counsel, being produced before the court on the next date. Next one. After 2 weeks, give a date.
Please.
34.
Please, Your Lordship. We are awaiting instructions in this matter, Lordship.
The last order, my lord, is 9/4/2024. my lord.
Just a moment. Yes, what is your prayer?
Lordship, we are awaiting instructions, Your Lordship. Your Lordship may be
How much?
kind enough. 3
How
weeks,
much
Your
time?
Lordship. 3 weeks.
3 weeks. Both sides are represented.
The prayer of interim, sir. Thank you, lordship. Kindly tell
What
me.
is your interim prayer?
Well, just to keep one post vacant, my lord, there are total 808 posts of office cum field assistant, my lord, vacant. Page number 124, my lord. RTI has revealed, my lord. Serial number 3, page 124, my lord.
Just a moment. No, you have already been out of service.
Out of service.
If your appeal is allowed, they will always give you. You don't need an interim order for that.
I had participated in a selection process, my lord. Because of the termination order, I was debarred from for future employment in APDCL any further, my lord. Now I have participated in the selection process and pursuant to that 695 posts.
No, we
were
can't keep a
filled up
post vacant.
and 800 posts are left
We
vacant.
can't keep a post vacant because if you are terminated from service, unless that is washed off, you can't have an employment. We can't reserve post for you. It will always be prospective. If you are exonerated today, you will be permitted to participate from today onwards.
I had already participated. My
No,
lord.
no, you can't be permitted
Because,
because there can't be a reservation for you.
Prima facie, my lord, there was only 3 grounds of rejection, my lord. Those 3 grounds, if I may just point one page of the writ
Definitely,
petition.
why not?
My lord, if your lordship kindly sees the rejection at page 121, my lord. Page 121. So
Yes.
my appeal was rejected on 3 grounds. Ground of rejection, one is, my lord, enough opportunity was given when the inquiry officer had done the inquiry and in the process of statement of various persons were taken and thereby was issued show cause
Mr.
notice.
Barba, you're clubbing two things together. What you are making me read is an order of the appellate authority
Rejection.
dismissing your appeal.
My lord.
Correct.
Correct.
It has got nothing to do with your future employment for which you had participated.
Because the first order of termination, my lord, will find, I just point out, my lord, page 48.
Please tell us, without interfering with the order of termination and appellate order rejecting your appeal, can we say that one part of the order will not be applied?
That is not what I'm suggesting. All I'm suggesting, my anxiety is if during the pendency of this writ petition, because this is the grounds undertaken are very good grounds. If they fill up all the posts, my lord, I will be nowhere. Or may I put it in this way, my lord, instead of pressing the interim, can it be this way? An endeavor may be
No.
to dispose
No,
of the petition in admission stage itself.
You see, please try to understand.
My lord.
You take up the matter with your bar association.
Right.
They will have to, you all have to take a decision that matters will be heard only in the admission stage, or in the hearing stage. All the matters are being pressed for hearing at the admission stage. Now, if I say that I make an endeavor, that means I am binding myself. Why should I bind myself when I am working for the entire day? And we can only do work what can be humanly possible. So endeavor, I'm not going to make.
Each case have their own peculiar factors.
Mr. Barwa, I am not binding myself with my own order, undertaking to clear up your case within next date. That I am not going to do because I am incapable of doing it. I can't assure, because you see, you will have to file an application for upgrading your case. Otherwise, why will I not hear the matters of your other brothers and sisters?
No, definitely.
And take up your matter in the precedent?
I'm not saying my matter is
No. You see, there are two things. Number one, which is very apparent. Number one, your service has been terminated. And you're debarred from future employment. That will get clear only after we exonerate you. Until it is not done, you can't be permitted to participate in a selection process where there is a standing bar. You can't do it.
But in my case, I have already participated and I was selected also.
No, that will create a bar and we can't.
Because
your selection will not.
Because in my case, my lord, I was already, my roll number was already there. I was selected, my lord. My document verification process was also completed.
No, it can't be done. You show us any authority where such a procedure is permitted. You show us any authority. You see, this is not the first case in the country. There may be hundreds of others So if there is a bar created in re-employment after dismissal of service, and you see, that order is permissible under the service law,
Correct.
which is the law which is governing you, which act is, rules are governing you.
Correct. Well, that ACB rules and regulations.
Show us that copy.
Just point out, I'll have a copy, my lord. I made a Xerox copy. If you're, this there, my lord, regulation, my lord, 10D. I have given the relevant extract.
It's okay. You only need that part where there's a bar created
My lord,
for re-employment.
my lord. Regulation 10D. Now, as per the departmental appeal, if a lordship sees, because they are taking recourse to regulation 10D. Now, 10D says, my lord.
Which page?
My lord, the second page, my lord, chapter 7, disciplinary action and punishment, regulation 10, my lord.
Yes.
May I just read out, my lord?
Yes.
Every employee of the board shall discharge the duties assigned to him with integrity, loyalty, and promptitude, and carry out the reasonable and lawful orders of his superiors in respect of the work allotted to him. Without prejudice to the generality of the foregoing clauses, the board may prescribe such rules of conduct as may be deemed just and fair, provided that the acts and omissions listed below shall be treated as misconduct. Now, my lord, subclause D, my lord, it says, same page, taking or giving bribes or illegal gratification. Now, they held me guilty under 10D. Now, if your lordship kindly turns to the next page, my lord, at the bottom, the last paragraph says, no order imposing a penalty shall be made unless the employee concerned is informed in writing of the alleged misconduct and is given an opportunity to explain the circumstances alleged against him. Before passing orders awarding a punishment, the competent authority may make such further inquiries and give such hearing to the employee against whom misconduct is alleged as may be considered necessary, and shall take into account the gravity of the misconduct, the previous record, if any. So therefore, my lord, before they impose a penalty upon me of such a stigmatic nature as what has been impugned in the present case, they have to give me an opportunity of hearing, my lord. In my case, my lord, they issued the show cause notice and they terminated me, my lord.
Who was the inquiring officer?
My lord, your lordship will find, my lord, the inquiry report, my lord, page number 49, my lord. It starts at page number 49. Page number 49, my lord. Your lordship will kindly note the date, my lord. Page number 49, inquiry report dated 17 September 2020, my lord. Page 49, my lord. 17/9/2020. And my lord will see the show cause notice at page 44, my lord. Page 44, my show cause notice, 28/9/2020. So that means, my lord, even before they issued me a show cause notice, the inquiry against me was already over. Show cause is at page 44, my lord. Your lordship will kindly see, my lord. Page 44.
Yes.
Notice for showing cause against termination from temporary engagement, and they say, whereas the report dated 17/9/2020. So the inquiry report, the so-called inquiry report, preceded the show cause, my lord. So they reduced the issuing of show cause to a mere formality. The inquiry cannot precede the show cause, my lord. They give a show cause, I give a written statement. Thereafter, they conduct an inquiry. Thereafter, they normally, my lord, that is what the rules prescribe. Thereafter, they impose the penalty. In my case, they conduct an inquiry. They finish the inquiry. They give me a show cause as a, my lord, mere formality. I respond to that, denying the allegations, and they terminate me, my lord. So the vindictiveness is apparent on the face of the record, my lord, in my most humble submission, my lord. Page 44, my lord, show cause. And if your lordship sees the perversity of the appellate authority,
No, that's still the interim order is not called for.
I think I leave it to your lordship. And that order of, if I may just point out,
Yes.
page 121, my lord, the ground of rejection, the third line. Page 121, the first ground of rejection, third line. The employee himself admitted twice, that is why statements on 25/8/2020 and 27/8/2020. Your lordship will kindly mark these two dates. Now, if your lordship kindly sees the inquiry
No,
report.
no, you see, I'm not prepared for merit. I'm
Well,
not ready
well, I'll leave it.
for the purpose of hearing today. The only question is about the interim order. That interim order, I'm not inclined to.
I'll leave it to
give.
your lordship. Let them file the affidavit as soon as possible, my lord. We can finally
So
decide.
there's two way of doing it. Number one, I merely don't say anything and I adjourn it. Number two, I take up your interim prayer for interim relief and reject it.
Or your lordship can, well, the first option will be better,
Better.
because otherwise it might affect at the
No,
time
that-
of
I know
final.
that. That's why I'm putting you,
No.
I'm giving you an option where you can't say no.
I'll take the wise option.
Well, Mr. A.K. Barwar and counsel for the petition.
And
So, Mr.
Sharma, your lordship.
And Sharma, then it's standing also for the APTCL. This one is granted 3 weeks time to file affidavit in opposition in the matter. Next, Barwar. The respondents shall take note that if an affidavit in opposition is not filed within the time allowed, comma, in terms of order dated 9/4/2024, comma, the prayer for interim relief shall be considered on the next date. We take back this.
Time being item 19.
Deeply obliged.
I'll also tell you why I was not inclined to grant interim relief. You see, there is a previous adjudication of this court. There is a in last paragraph, there is some observation.
Yes. Well, deeply obliged, man. Deeply obliged.
Yes,
My lord, in item 19, we have received the records, my lord.
you received the records.
Yes, my lord.
Please pass it on.
My lord is taking up the matter today, my lord.
No, no, I'm just trying to
Wait on,
find out something.
my lord. I even put on go through the record also, my lord.
Oh, you have not gone. Oh,
My
then
lord-
it's okay, then not required. Not gone.
My lord, what happened actually, today I was not allotted this code. I am in a different code, taking up the government matters, my lord. So as soon as I saw it, my lord, I was in a shock. I came running, my
So
lord.
if you are not in this court, you are in foreigners tribunal. Where are you?
My lord, I am in court today. I am in court 13, my lord.
No, but it's still the High Court.
In the High Court, I am in my lord's court, my lord.
Okay.
So we have
Okay.
received my lord will fix the matter. Since
Okay, go through it.
pleadings
When
have
do you
been
want?
exchanged,
When do you want?
my lord, it's up to the petitioner. I am always there, my lord.
No, no, you have to go through the records. When you are
My
ready.
lord, after 1 week then, my lord.
Okay. Both sides are represented. Mr. Arthur and additional senior government advocate
My lord.
submits that he has received the records,
Madam.
but could not go through it.
Madam.
Just calling a matter and judge on today, list after a week. Give a date after a week.
The date is
22/5.
On 22, I have got some personal difficulty.
24/5.
24/5.
Okay. Yes, item
Supply item 49.
Deeply obliged.
yes, dues of the petitioner.
Lordship, instruction received. No unpaid dues are pending, Lordship.
Show it to him.
On last occasion, I have seen this, madam. After going through this, madam, if your lordship comes to my para 9 of my petition, madam. All right.
Yes.
Madam.
Yes.
Madam, since madam, the employee expired, madam. Madam, the petitioner expired during the pendency of this case, madam, on 11/8/2022.
Okay.
Now, madam, his wife has approached this court only for the, madam, the salary, madam, salary portion. You can see my para 9, madam. I have
Para
category.
9, yes.
Yes, madam. He was not allowed to sign the register, madam.
He filed a affidavit in opposition.
Yes, madam.
But they've already filed an affidavit in opposition.
But they have filed, madam. They have filed. Regarding the salary portion, madam. Your lordship may also see page 11, madam, of my petition, madam. During the period January 2021 to June 2021, he was paid only rupees 49,000, madam. His fixed salary is rupees 30,000 per month. This was stated, madam, in the petition, madam. Another page 11, madam. Para 12. And if your lordship sees the pair portion, in the pair also, madam, we have paid for the area salaries at page 16, madam. Last second line, madam.
You see, please come to Mr. Das, please come to page 93.
Madam.
Your affidavit in reply. Madam. Now here two things have come up. Here you take a plea that your that you have suffered some
Yes, madam.
mental issues.
Yes, madam. Yeah.
Correct.
I was admitted at this
No,
madam.
it's okay. Whatever be,
Yes, madam.
that you had some mental issues.
Madam.
And then you say that you were called in the office of the DDO and then you were made to admit your guilt.
Yes, madam.
Correct.
Yes, madam.
Now, I have not found anything in the writ petition where you have challenged that, where there is any challenge to the admission made. Now, if that admission does not go away,
Madam. Yes, madam.
then the rest of the things which you are trying to communicate would not be complete. Because you have to come out from your admission.
That's all.
Please take a call. I'm not very sure. This is something which, after which I could not frame up my mind. So therefore I stopped there. So you have to make your submissions based on these two facts. How do you assimilate or how do you overcome this? Because you can't say once you are taking a plea that you were not in a good mental condition.
Yes,
Then for that period you can't be working unless the authorities condone that what do you call that that leave period.
Yes, ma'am.
Because this is something which was never agitated.
Lordship will see my page 20, madam. Page 20, madam. I was in the hospital.
No, I'm not disputing.
Yes.
So that's, I'm not saying that what you're projecting is incorrect. What I'm saying is that how do you come out of it? Because you are saying that you should be treated as working because till that period is not condoned. And in order to show it that that you are genuinely absent, you have also tried to introduce that that your controlling officer was in fact given a show cause notice.
Yes, ma'am.
Departmental proceeding was sought to be initiated against him. So you see, these are independent facts. How do you correlate and make it a chain? So then the lordship will come to page 24, my lord. This letter was issued by the director to the GFDO regarding some false communication. Last para, my lord. Only to suppress this, my lord. We have said that in order to take a revenge, my lord.
No, that's okay.
Yes, my lord. This is the letter, my lord.
No, Mr. Das, I'm not saying it's incorrect. What you're saying is incorrect. I'm not for a moment suggesting that. Please, you see, these are independent facts. Show cause notice to X. How does it help you? Because unless there is a finding of fact recorded in that show cause notice saying that they have misled the authorities. So therefore, what I'm saying is that these independent facts, how do you make a chain out of it?
My first thing is about the termination which they have made, my lord. That is bad. But in a sense, my lord, since I was a contractual agreement, employee, my lord, the agreement was signed between the employer and the employee, my lord. But in the affidavit, my lord, they have mentioned that as per their HR policy was not a part of the record, my lord, the agreement. We have answered to that.
What policy?
HR policy, my lord.
HR policy, okay.
ma'am.
HR
Yes,
policy.
HR
okay.
policy was not a part of record of the agreement, my lord. So, my lord, the termination was bad, my lord. And without making a proper inquiry, my lord, it will be against the national justice, my lord. Termination will be against the national justice. So, my, at this point, my lord, since he expired, my lord, he was just claiming that area salaries, my lord. In the prayer person also, my lord, we have made the prayer, my lord. Since he was in hospital, my lord, for that period, and no show cause was issued to him. So now let them file a affidavit showing the salaries which they have given to me, my lord.
That they've already disclosed on that day.
Regarding salary, my lord, they have not said so much.
Yes, 49,000 something was there.
That was for the
Regarding
period.
salaries, my lord, we have received an instruction. That instruction say there is no any pending honorarium. The petitioner and no pending dues against the unpaid salary of the deceased husband. But affidavit is not necessary, record is there. Affidavit we have already filed, so cause was issued to him, he confessed, he accepted. Regarding pending, my lord, there is no pending dues.
Okay, if time permits, we'll take it up in the last item, the time permits. Mr. Chair, will try to hear the matter if time permits in the second half. Because the substituted petitioner is a widow asking for salary. I think we should take it up out of turn.
Item 35 for orders.
You have not taken steps. Is office not saying that you have not taken steps?
Maybe, my lord, I may be allowed some time.
Okay. In view of office note dated 30/4/2024, indicating that steps for service has not been taken upon respondent numbers 1, 2, and 4, Mr. Salim Land Counsel for the petitioners prays for some time to take steps. Prays for is granted 1 week's time to take steps. Subject to steps being taken within a week. Let them notice returnable on, give a date after 6 weeks. This one should be issued.
17th of July, 17/7.
So it should be issued. List on 17/7/2022.
Item 37.
Your lordship,
Yes.
the order has been complied with.
Complied with. Okay. Upon instructions, Miss
K. Burman.
A.
K. Burman.
K. Burman. appearing on behalf of advocate, appearing on behalf of Mr. K.R. Padgiri, counsel for the petitioner, submits that the order of the court has been complied with. And she has instructions not to press this contempt petition. According to this, according on compliance, this contempt petition stands closed.
38,
Yes.
My lord, say a new secretary has, and my lord, new commissioners come in, but I have taken instructions. We
But
need
what-
some further time.
But what,
Contempt, my lord, this person, he was suspended. Then he approached the court. Court directed to reinstate him. But in the meantime, my lord, he retired.
no, but his reinstatement has to be done.
Yes, it is under process, my lord. I just spoke to the secretary. Just need some time. my lord.
4 years, my lord.
Well, unless he is reinstated, his
Yes,
other benefits will not flow.
Nothing, my lord, till today, my lord. Not a single penny.
Just some time, my lord. I assured them, they have assured that they are taking it on priority basis.
How much time?
2 weeks may be given.
Mr. Aaron Dingyal, then counsel for the petitioner is present. Mr. D. Gogoi Lanet, standing for the Forest Department, the land counsel for the respondents. Raised for further 2 weeks' time to obtain updated instructions regarding compliance of the order of the court. Next para list on, give a date after 2 weeks.
What are you doing?
3rd of June.
My lord. Obliged.
Item 39,
Your Lordship. Your Lordship, the order has been complied with.
Complied with.
Madam.
Your name?
Miss S. Jain, Sanjukta Jain.
And Ms. Sanjukta Jain, and counsel for the petitioner, who upon instructions submitted the order of the court has been complied with, and she has instructions not to press the matter. Yes.
Lordship,
MD Bora, learned counsel for the respondent,
7.
number 7 is present.
Lords, deeply obliged.
Matter stands. On compliance, the matter stands closed.
Obliged.
Yes, Mr. Sinha.
Yes, my lord. In this case, a petitioner was to be recruited in the Assam Rifles as the translator of Hindi. Then he was declared not selected. Whereas one Mahadev Singh, Chaityadev Singh has been selected in the OBC category. So he has filed writ petition before this honorable court. And this honorable court, as per order dated, your lordship will find. This is the first writ petition. Your lordship will find Annexure 8, page 38. So this honorable court, by this order, has held that this Satyadev Singh, your lordship may look into page 40 and serial number 6, page 40.
Yes.
Yes, according to Satyadev Singh, having secured 52 marks, who was also eligible on merit as a general category candidate, and we see no reason as to why his appointment should not be construed to have been as a general category candidate. If Sri Satyadev Singh is construed to have been appointed as a general category candidate, the petitioner who secured 51 marks would be the highest in the merit within the OBC category, and therefore he is also be entitled to an appointment in the OBC category. So, my lord, here for general category 1 seat and OBC category 1 seat, so that if Satyadev Singh is taken out in the general category, then OBC category, the petitioner case is to be considered. Now, one point is that the case of the petitioner did not consider by the department because the petitioner is lessened by 1 centimeter in the height.
your lordship will find in the same judgment, page 41, paragraph 12. Paragraph 12,
Yes.
page 61. Yeah,
Yes.
41, paragraph 12. Another issue raised by Mr. K.K. Poraswar, learned CGS, is that the required height for the post of Hindi translator in Assam Rifle is 170 centimeters, whereas the petitioner was found to be 169 centimeters, but the respondents, by adopting an incorrect proposition which provides for a relaxation of 2 centimeters in respect of those candidates who have their close relatives already serving in Assam Rifles, was given the relaxation in respect of height. But later on, the authorities found that such relaxation is applicable only in respect of sons and daughters of an existing employees, and not in respect of siblings who may be otherwise serving in the Assam Rifles. So on that ground, the case of the petitioner did not consider, and the petitioner has approached this honorable court. Now, in the round of this writ petition, the respondent has come that the petitioner is not a word. Petitioner is not a word, so relaxation granted to those words cannot be granted to the petitioner because his brother is working in the Assam Rifles, but he is not the word. Your lordship will find the certificate issued by the Assam Rifles. Your lordship file annexure that has not been considered by the respondent.
Where is the criteria?
Criteria is that 2 centimeter.
No, where is that?
Yes, yes, certificate. Certificate. Yes. Page 43, annexure 9. The relationship certificate issued by the.
No. As per the rules, first the.
Yes, that is the rule they say, my
Page
lord.
18, now. Page 18.
18.
That is the rule, my lord. Where is the rule? That is, my lord, that now question to be determined by this honorable court. What is the rule, my lord? How the relaxation can be granted? Page centimeter, there is the advertisement that 1 centimeter, 70 centimeters is required.
Clause 14, my lord, there are strict sub clauses A, B, C.
$170.
My lord.
Okay. So why you have relaxed 1 centimeter for another man? So somebody, this height was relaxed. Is
There is a provision of relaxation, my lord. That circular they have to produce. They are not producing that circular. By what they say that if it is only for word, then I am out. But if it is also applicable for my lord relatives, my elder brother is working in Assam Rifle. Certificate issued by the department, my lord, annexure 9, page 43. Considering this, my lord, I have been, my lord, allowed in the exam also, my lord. In the
see, participation in the examination has got nothing to do with physical. Nowhere I have found, or at least show it to us.
Now, in the advertisement, it is not mentioned.
No. You have to first show us that sitting in the examination is a precondition that your physics is okay. Your physical test, you are okay.
After having qualified in the physical test.
Qualification is okay.
Yes, madam.
Because if they show us from this recruitment advertisement or from somewhere else, that once you are permitted to sit in the written examination
Yes.
or the other examinations, that means physical test and others you have passed.
Yes, there is another 10,
Page
page 44.
44.
Yes. It's only in the result I have been, my lord.
You have understood my question.
Yes, I could understand, my lord. I have been allowed to sit in the exam also after
Does it
every
mean-
part.
That's okay.
Yes.
Does it mean that the defects in physical fitness is condoned?
That is the thing. Once they have allowed it, my lord, then only I could sit in the written examination. And later on, only in the result, my lord, I was not selected.
I don't know, because you see, I've been I've been a part of the team having recruitment examinations in this court on several occasions.
Yes.
At the time of Viva, normally we call all the original documents and have it inspected. At the time of examination, we allow, you see, people whom we allow to sit in the examination turn up to be the either grade 1 officer
Yes, madam.
of district judge level,
Mhm.
or he is admitted, or he or she is admitted in the grade 3 judicial officer, wielding so much of power. So we permit them to sit in the examination with whatever credentials they want to project. Till today, I have not scrutinized any application at the time of examination. But when it comes to Viva, then there is a strict guidelines which are followed for having an inquiry made with regard to the antecedents, with regard to the other parameters. So this is my limited experience. I can't say that I have vast experience, but
Your
limited
lordship was bad
experience I have.
experience, madam. Only here also same thing happened, man. Only the result, I have been declared as not passed. Then only I have come to know that I have been lessened in the one.
No, you see, the relaxation, whatever is there,
Yes, ma'am.
must be in the advertisement.
Advertisement, it does not mention, ma'am. It did not mention in the
Then
advertisement.
you don't get a relaxation. You see, not one. There are several judgments of the Supreme Court which says that the criteria would be only the advertisement. Yes, Mr. Goswami.
Not in the advertisement itself, Malam, provided that clause 7, page 17,
Page
candidate
17.
belonging to physically handicapped or other category is not eligible for advertisement.
Page 17.
Malam, he has, at the time of Viva, definitely that written step examination. He has not, prior to that physical test, he has not found any defect.
No, that's okay.
Subsequently, they come to the knowledge that he is lesser than 1 centimeter in the stipulated
No, that's
170
okay. Please
centimeters.
show us
So
from
he is
here.
definitely
No,
not.
please show us from this recruitment. Page 79 there. Which
17,
clause?
17 in the clause that candidates for
Which clause?
5, clause 5, standard
5.
and so and so, so and so. This test is required to be done within these centers. And candidates seeking reservation benefit also, these are mentioned there, Malad. But he have to verify these clauses, then he have to apply. And because in page 18, clause 14, it is specifically mentioned the height of the candidate. He is less than the
175.
standard height. He ought not to have applied. Less than the stipulated height, admittedly is lesser. That is why he was not selected subsequently. He should not have applied. He is not even eligible for the advertisement. So there is a lot of judgment. He, at the time of advertisement, is a person concerned is not fulfill the basic required condition of the advertisement. He is not entitled for appointment.
There is a relaxation clause also, my lord, in respect.
Show us, I am asking for.
Yes, page 18, 14, clause
Page
14,
18.
serial number 14, page 18.
Yes.
Of my lord, there is a relaxation clause, my lord.
Show us.
This A, this in respect candidates falling in the categories of Garuwalis, Kumauns, Douglas, so and so, so and so, so and so, so and so. Then Manipur, Mizoram, Tripura, Arunachal Pradesh, Meghalaya, Himachal Pradesh, so and so, so and so, so and so. There is
This is not a relaxation, this is a prescription. 157 centimeter for
it is
people in
there,
Assam
it is there, maybe
is a
somewhere there.
prescription, not a relaxation.
The clause 15 also say, my lord, the candidates falling in the categories of Garoli, so and so, so and so. There is general is required at 170 centimeter. Now, by relaxing it, it came
No,
to
you see, it's not
one-
relaxation.
62.5.
Okay, Mr. Sinha.
Yes, madam.
It's not an acceptable argument.
Madam.
You see, there's saying that if you are for grade 1 officer, you should be minimum graduate. Then it says that if you want to be appointed as a clerk, class 8 is the minimum prescription.
Yes, madam.
Will you say that for clerk, there's a relaxation? It's a prescription. Prescription can't be relaxation.
So one day time maybe can be given, my lord. I will examine it, my lord. Only one day time. Tomorrow we'll also may take it, my lord. In this lesson, I will examine, my lord. Only one day time.
List on 15/5/2024 as paid for by Mr. B.P. Sinha and counsel for the Mr. B. Sinha, counsel for the petitioner. Mr. U.K. Goswami and CGC is present.
Obliged.
You also 15. You also have that judgment where it says that any recruitment examination, the advertisement has to be followed.
Obliged.
There's also this court and also Supreme Court. We have followed Supreme Court.
1997 onwards.
Yes, yes, please have that ready.
Item 40 for orders.
Please, Your Lordship.
Yes.
Proceeding the matter pertains to non-payment of retirement benefit. Your Lord.
My lord. Yes.
I'm appearing for the corporation, my lord. My lord, the managing director of the corporation is my lord transferred, and my lord new managing director, my lord.
No, but this this contempt is a contempt petition.
My lord.
The respondent is Anamika Tamuli.
My lord, he is my lord. Is now my lord new
No,
managing
now
director.
we understand, but you have to show us that during the her tenure.
Yes, my lord.
What did she do? So
My lord, already we have filed my lord the my lord affidavit on her
Affidavit.
side, my lord.
Okay.
And my lord, the new development, my lord, actually last year, my lord, due to some formality, my lord, we have missed the, my lord, budget allocation was also there, my lord, last year also, but that is returned, my lord. And now, my lord, in this year, my lord, again, my lord, assembly has approved the, my lord, budget, my lord. And now, my lord, under my lord, 24th April, my lord, this is the latest communication, my lord. We have already, my lord, fresh, my lord, file, my lord, my lord, all the proposals, my lord.
Sure, sure. That.
the director, my lord.
Okay, postponing it for 4 weeks then.
My
Mr.
P.S. Raja, my lordship. P.S. Raja.
P.S. Raja.
Yes, my lordship.
Mr. P.S. Raja, counsel for the petitioner. Next, brother. Mr. B. Sharma,
My-
counsel for the respondent, has submitted that the respondent has been transferred by order dated
by order dated, my lord. My lord, actually, my lord, Onamika Tamuli, my lord, transferred earlier, my lord. Then, my lord, one B2 Talukdar came, my lord, then he also transferred, my lord. Now, my lord, this is the fresh, my lord, order. That's the first one, my lord.
My lordship, I would bring some, I would like to bring into your lordship's notice. I have already filed a representation. I have already filed a representation to Chitumani Talukdar.
My lord.
But the new incumbent has come in. I have to file a representation to him also, my lordship.
First one, my lord.
Before impleading him, he came into picture, my lordship.
has already been transferred, and in her place, one Jitumoni JITU MONI Talukdar was allowed to hold the charge of Divisional Soil Conservation Officer, Kokrajhar, by notification dated 2/3/2024. The General Counsel for the petitioner has submitted that a representation dated
31/2024.
30/1/2024 was submitted to, we said, Jitumani Talukdar. Full stop. Next para. The learned counsel for the respondent has submitted that in the meanwhile, the said Jitumani Talukdar has also been transferred, and a new incumbent, namely
Ramendra Nath, my lord, Das, the first one, my lord, first one.
Okay, Ramendra Nath Das, planning officer, BTR, was allowed to hold charge of managing director, APCDCL, Lokra Guwahati, by notification dated 2/3/2024. Next, the Learned Counsel for the petitioner shall take note of the said statement and do the needful. Next, para. The Learned Counsel for the respondent has produced a copy of communication dated 24/4/2024 by the managing director, APCDCL, to the director of director of Soil Conservation Department from Assam, by which proposal has been submitted for leave encashment and gratuity of 37 numbers of retired employees of APCDCL. Next one. Accordingly, the Learned Counsel for the respondent, the matter stands adjourned today, so as to enable the Learned Counsel for the respondent to inform the court about the budgetary allocation, if any, received specifically regarding the dues payable to the petitioner. Next panelist on, after 4 weeks, due date.
19th of June.
Before that, you write, before this last line, you write, the said communication dated 24/4/2024 and the notification dated 2/3/2024 produced by the Learned Counsel for the respondent is retained on the record.
Right.
After this, list one, so and so.
Item 41.
May I please, Lord?
Yes.
My lord, in this case, my lord, respondent number 1 has filed their affidavit, my lord. Matter is pertaining to the grant of minimum of pay scale, my lord, in terms of judgment of Upendas, my lord. And kindly see the operative part of the order, my lord.
What
Page
has happened,
nine.
Mr. Budgetary?
My lord, the proposal, my lord, for the grant of minimum of pay scale, my lord, that has been forwarded to the finance department, my lord, by the revenue department. I am appearing on behalf of R1. R1 has already filed an affidavit, whereby that stand has specifically been taken. In view of the stand taken by R1 in his affidavit, my lord, this honorable court was pleased to, my lord, implement R3 as, my lord, he is holding the post of Commissioner and Secretary, Finance Department. Now, admittedly, my lord, the matter is pending before the Finance Department. In the meantime, my lord, they have, as petitioner side has submitted the amended first title, they have also taken steps. My learned colleague is appearing on behalf of R3.
My lord, another problem is that, my lord, now, my lord, the respondent number 1, my lord, revenue department has stopped the salary, whatever he was earning, getting, my lord. Stop the salary from the month after March, my lord. He was getting rupees 1800, my lord. That they have stopped, my lord.
Lordship, here our name was not shown today. Lordship, we have filed the Wakalatnama. Lordship, I can, if Lordship grants me just 10 days, 2 weeks time, Lordship, I will get a updated status regarding the compliance I will propose.
And if he's alleging that the salaries has been stopped from March, that will be again contemptuous.
That, my lord, perhaps will be another cause of action because here he was.
In a contempt, you may never know. It may be considered as a continuing contempt because once a contempt notice is issued, then you stop the salary.
No, my lord, here, my lord, one aspect of the matter because he was working under the establishment of Deputy Commissioner at Morigaon. So, my lord, I am representing the Principal Secretary of the Revenue Department. Now, the least before this honorable court was that he was claiming, my lord, minimum of the pay scale in term of the dictum in Upendas, my lord. Accordingly, my lord, the department had forwarded all the proposal. My lord, having accepted the plea, my lord, and having admitted the claim of the petitioner that he is entitled to minimum pay scale. To that extent, the entire exercise was done. Now, my lord, if the my lord, plea is forthcoming now, my lord, from the petitioner's side, that off late, my lord, his salary has been stopped, that perhaps he will be, my lord, he will have to, my lord, include the Deputy Commissioner Morigaon, my lord, because the appointing and the controlling authority is the DC under whom he is working, my lord. It is not the Principal Secretary whom I am representing, my lord. This is my humble submission.
Okay.
So far as, my lord, the order passed in the read petition is concerned, my lord, R1 has duly complied. There is no denial to that. Even he is not denying, my lord. We have sent the proposal to the Finance Department.
Okay. Mr. AHMR Chaudhary, counsel for the petitioner, and Mr. R. Budgetary, learned counsel for respondent number 1 are present. Next paper. Mr. H. Alial and counsel appearing for the newly implemented respondent number
3.
3.
3, my lord.
Yes. Has submitted that his name was not reflected in the cause list. The listing has escaped his notice. So he prays for and is granted 2 weeks time to obtain instructions in the matter. Stop. No, you are respondent number 2, Samir Sinha.
Now respondent number 2 is no longer in the finance department. Respondent number 3, Jayan Narlikar, Lordship.
No, I don't know. There is no such person here.
Respondent number 3 is here.
No, he has
No.
filed an amended cost title, my lordship will find it in the record, my lord. Pursuant to the last order, my lord. Perhaps, my lord, a short 2-page amended cost title is there, my lord. The 2-page or 3-page cost title. my lord.
Oh, acha. He's for 1 and Mr. Bapuzeri for
R1, my lord.
R1 and Mr. Shadia for R3.
So far as R2 is concerned, my lord, he was never served with any notice, my lord, and nobody has appeared on his behalf.
No,
Since
because
long,
neither ID card nor answered notice is returned. Next, in view of the office note dated 25/9/2023, the petitioner shall take first steps for. Oh, Samir Sinha is not the finance department.
no, my lord, in the meantime, he left finance department. That is why, my lord, R3 has been newly implemented by filing that amended cost title.
Acha, okay.
Now, my lord, they have only
This-
demanded, my lord, compliance by filing a representation.
No, that's okay, but I have to deal with it.
My lord,
As for office note dated 25/9/2023, neither AD card nor unserved notice has been received back in respect of respondent number 2. So in the said context, Mr. R. Bapuzeri, Learned counsel for respondent number 1 has submitted that as per his instructions, the respondent number 2 is no longer connected with the finance department.
my lord.
So the learned counsel for the petitioner shall take note of the said submission and take necessary steps to bring on record the correct postal address of the respondent number 2. So thereafter, orders will be passed for issuance of notice on the respondent number 2 at the correct postal address. Next paragraph. The registry shall reflect the name of Mr. A. Salia as counsel for respondent number 3 while listing the matter next. Next paragraph, list after, give a date after 2 weeks. List on instance was to enable the learned counsel for respondent number 3 to obtain updated instructions. Next paragraph. The pendency of the contempt petition shall not be a bar for the compliance of the other report.
Yes, my lord. In all probability, it will be done, my lord.
It's okay.
Some last minute formalities are going on, my lord.
That's okay.
5th of June.
5th of June.
My lord, can it be 10th of June, my lord?
10th. 10th.
10th of June.
I'm so obliged.
42.
Make your lordship. Lordship, as per office order dated 34/24, counsel for respondent number 1 appears with Wakalatama and neither AD nor unserved notice has been received to respondent in response to notice issued to respondent number 2, lordship.
Okay, yes.
I'm preparing for respondent number 1, lordship. And lordship, respondent number 1 is already been lordship transferred to some lordship. In his place, lordship, there is a new incumbent has come.
No, but for the
And
period he
affidavit
was
is
in
ready, lordship.
contempt.
In my affidavit is ready, lordship, within week I will.
Okay. Mr. Nath. See if this person is still there. There is Sanjeev Shyam.
Yes, my lord.
He's still there.
Yes, Chief Engineer PWD roads, he's there.
He's there.
He's- Well, it's, otherwise,
Miss
it's a-
P. Burman and counsel for the petitioner. Next one, Mrs. D. D. Burman and the counsel for respondent number 1
Yes, Lord.
has submitted that the respondent number 1 is no longer the deputy, no longer the district commissioner
Yes.
of Kamrup Metro. And the new incumbent is
Sumit Sattawan. Sumit Sattawan. Sumit Sattawan is name.
how do I spell it?
SUMIT. Sumit Sattawan. SATTA. MN. SATTMN.
First of the land council for the petitioner shall take note of the same and take necessary steps. Next paragraph. In view of the office note dated 30/4/2024, it states that that neither ID card nor answer notice is received in respect of respondent number 2. The petitioner shall take first steps for service of notice on respondent number 2 by registered post with ID. Next step within 2 days. First of all, the notice is made returnable on a fixed date after 5 weeks.
28/6.
Next, the London council for the petitioner is shall collect the postal receipt number from the registry and submit postal tax report prior to the next date of listing. Affidavit in opposition by respondent number 1 be filed by them.
I'd like that.
Forty-three.
Yes, and the updated status.
But here, Lordship's direction is dated 19/9/2022, Lord, at
Yes.
page 9.
Yes.
Lordship has directed the DGP to pass a speaking order,
Yes.
considering the representation.
Yes.
That has been passed, Lord, on 6/6/2023.
6/6.
I'm just giving a copy.
Okay.
6/6/2023, Lord. His representation has been rejected. Otherwise.
Okay. None appears on call for the petitioner. Next one, Mr. D. Nath, learned counsel for the respondent, has produced a copy of speaking order dated 6/6/2023, by which the representation of the petitioner was rejected.
Lord, the third last parameter.
It's okay. We're not saying anything.
Mal.
Rejected, and it is also submitted that a copy of the said speaking order has been communicated to the petitioner. Next paragraph. As the counsel for the petitioner and as the petitioner is not represented, for instance, the matter is adjourned today. List after 4 weeks. Next, the copy of the. You have a photocopy? No?
I have.
Just give me a photocopy.
Yes, sir.
The photocopy of the said speaking order dated 6/6/2023 is retained as a part of record.
I'll just give a copy.
Yes.
44.
We will have to initiate a contempt. Mr. Nath. Not in, we understand we can't ask you to appear in these matters, but
Look.
you see what is happening.
Well,
Your officers, they are making direct communication with the court
well,
in
this
contempt
is-
matters.
This is happening regularly. Well, in fact, today there is a case where in court number 1, honorable court has directed the deputy commissioner to appear personally because of this. That he has directly communicated to the registry now. But in fact, OM has been issued that they will not communicate to the honorable court directly. OM is there, my lord, on 3rd of January 2024. In fact, earlier also a lot of instances are there.
Yes.
They are communicating to the honorable court. OM is there, my lord.
So it also has the circle officer to be present.
This is item 44, my lord.
Uh-huh. Okay. Mr.
Islam.
K. Islam, counsel for the petitioner.
But possibly he is from South Salman, my lord.
Yes.
Yes.
My lord, this person, my lord, in fact, he wrote to the honorable court directly. In another case also, at the same time, my lord, because my lord, I know in one case, my lord, he was directed personal appearance. I appeared in that matter, and subsequent to that, my lord, this OM was issued. In fact, my lord, by that time, my lord, he has already written my lord 4 or 5 letters now.
Okay.
My lord, can I just pray before lordship, my lord?
You just see this. You are right. Maybe perhaps this because he wrote to the court in December.
True,
You're perhaps right.
True. Because
Yes.
because he is the circle officer newly joined there, and he has written 5, 6 letters he has written.
Okay.
And by that time, my lord, he has damaged it. In fact, addressing the one letter I have found addressing the honorable judge, my lord.
So just adjourn, we may say nothing today.
Lordship.
We just after 2
Well,
weeks.
My lord, I'll just talk to him, my lord. I'll just inform him.
I'm not recording our
My lord,
presence.
my lord. But I'll take care of it.
It's okay. Uh, a communication dated 7/12/2023 issued by the circle officer, South Salmara Revenue Circle, which is addressed to the registrar within bracket judicial of this court, has been brought to the notice of this court. First of the said response of not being in the appropriate form and not supported by an affidavit is rejected forthwith. Next one. In the displeasure of the court, communication being made by the contemners to the court was expressed in the open court from Mr. D. Nath, a senior government advocate who was present, has submitted that the state government has already issued an office memorandum to dated, what is the date?
3/1/2023.
3/1/2023.
I'll just give it.
It's okay, we're not required.
I'm giving.
It's not required.
Lot.
3/1/2023. Informing all the state government authorities that direct communication to the court should not be made.
It is office memorandum by the secretary to the government of Assam Personal Aid Department.
Office Manual so issued by the Secretary to the Government of Assam,
Personnel A department.
personal within bracket A department. Just one. Next, be that as it may. For answer justice, the matter stands adjourned today. To stop if the respondent does not file any affidavit in opposition to the matter, he would be risking initiation of a contempt. Full stop. List the matter and give a date after 2 weeks.
That
5th of June.
Honorable.
Only in that respect, we are recording your name, we are not recording any questions. But this, what you call, please go through that response. He has given a reason for not being able to do it. He is not the DDO. He can't do anything.
Not to what?
No, not that. For the petitioner, you must take note of what has been said. Just go through that response.
Honorable.
45.
As per office note dated, my lord, 4/5/2024, my lord. Service upon the respondent number 1 is not answered, my lord. And respondent number 2 to 4, my lord.
You have to take first steps then.
2 to 4 is not complete, my lord.
For one also, you have to take, if
My lord,
he has transferred, you have to bring his.
First step on respondent number 1. I will take first step on respondent.
No, you have to bring his address on record first. It says left. Left means his address has changed, perhaps he's been transferred. For Mr. K. Kalika, counsel for the petitioner. Next, probably office note dated 4/5/2024 indicates that notice on respondent number 1 has been received back answered with postal remark address he left. Next, in respect of respondent numbers 2 to 4, neither ED card nor answer notice has been received back. Next, accordingly, the petitioner shall take first steps for service of notice on the respondent shall take steps within 2 days for service of notice on the respondent numbers 2 to 4 by registered post with AD. Post of the land counsel for the petitioner shall collect the postal receipt number and submit postal track report prior to the next visit of the district. Next, the land counsel of the petitioner shall bring on record the current postal address of respondent number 1. Stop. Thereafter, orders will be passed on the next date for issuance of notice on respondent number 1. Next paragraph. List on, give a date after 5 weeks. List on so and so.
28/6.
In the top, when I said issue notice, today, issue notice returnable on the same date.
It may be 3 weeks. 3 weeks, madam. Instead of
Postal
5
receipt, you can't take cognizance of 27.
No, I will file implementing petition, madam, in the meantime. Respondent number 1.
Okay. No, you do it. You see, there are 2 things. Number 1, if you want, we can defer the entire matter for 2 weeks. Correct, because you'll have to take steps on 1, 2 to 4. So that will also be adjourned then. Correct? Okay. Then don't write everything. Just a same thing. Issue notice from there you strike off. Accordingly, matter stands deferred today, this after 2 weeks, so as to enable the petitioner to take steps in respect of to bring on record the correct postal address of respondent number 1. Orders will be passed thereafter for issuance of fresh notice on the respondents.
Yes.
List on Spencer.
Date to nathakib sir. Date to thakibo ni.
After 2 weeks, date detail.
5th of June.
46.
May it please your lordship. Lordship, this I has been filed for the deletion of respondent number 4.
Okay.
Ex-
Your name
M. Tiwari.
and Ms. M. Tiwari and counsel for the applicant, and Ms. B. Sharma and SCGC for the respondent numbers 1, 2, and 3. Next. By filing this interlocutory application, the applicant, who is the writ petitioner in the connected WPC 2516 of 2023, has prayed for striking out the name of respondent number 4. Full stop. The said prayer, having not been objected to, stands allowed. Full stop. Consequential orders is being passed in the connected writ petition. In the writ petition, you say, but so and so. In view of the order passed today in the connected IA Civil 1261 of 2024, the name of respondent 4 is struck off. First, the registry shall carry out the registry of the concerned section shall carry out the necessary correction of the cost title by deleting the name of respondent number 4. Full stop. You have filed your affidavit.
Oh, you have already filed.
Okay. List after 2 weeks.
Obliged.
Mhm. 47.
This matter pertains to payment of leave encashment benefit as per Rule 39(6)(a)(2) of the Central Civil Services Rules by the department. Whereas we are entitled to receive the leave encashment benefit as per 39D of the rule. But somehow they have invoked the other provision and not the provision in which we are entitled.
Yes.
But I'm appearing for all the respondents. We will file an affidavit. In fact, 39D is not applicable here because in the writ petition itself, they have annexed. And
You filed your affidavit.
I'll file.
Okay.
I need one with that. I need one with that. I'll file
You're
it.
saying that
The 39D is not applicable.
this is not applicable.
Not applicable. We have adopted 39(6)(a)(2). And it is annexed in page 42 in the affidavit. Madam.
It's okay. You're saying that you have not adopted the rules entirely.
No.
Okay. But Mr. S. Biswas, Learned Counsel for the petitioner. Next, Mr. D. Nath, Learned Counsel, appears on behalf of the
For all the respondents.
for all the respondents. And place for him is dotted. How much time?
I prefer 10 days time.
Place for is dotted. 10 days time to file affidavit in opposition to the matter. List on. Due date after 2 weeks.
5th of June.
Gotcha.
Supply item 50. Item 50.
We're taking steps on 13 May 2024.
13 May.
13th of May. Upon the respondent number 3, but till now the step is not completed. So fix the matter after 1 week.
Okay, because Office note says that you have not taken steps. Correct.
There's a miscommunication with advocates clerk. He
No,
was
no,
instructed.
you please inquire. No, that's why we did not adjourn when you made the prayer on that in the morning. Miss
G. Bora.
G. Bora, learned counsel for the petitioner, has submitted that she has taken she has taken steps for service of notice on respondent number 3 on
13th of May, 2024.
13.
Yes.
13/5/2024. Full stop. As per the office. Today, you have taken today. Today is 13/5.
Oh, yes.
You've taken today. Must be taken today. Full stop. The registration shall verify. And issue notice on respondent number 3, which is made returnable on after 5 weeks on so and so. The petitioner shall collect the postal receipt number. The learned counsel for the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing. List on
28/6. 28th of June. Item 49.
So far, I have gone through it. As per rules, policy of the air, 1 month notice prior to termination, 1 month notice is sufficient. Either party, if he want to resign, he will have to give 1 month notice. If he want to terminate his service, 1 month notice. That's why this impugned order, the annex here last page, lots of can see. Page 46. This is 30th November 2021. He challenged this one, with reference to the subject cited above. This is to inform you that as per letter from the state project director, ARIS Society Khanapura, under reference above, you will be terminated from your temporary engagement as engineering consultant, so and so, with effect from 30th December 21. 1 month notice has been given. Due to poor performance and prolonged absence in the duty. Absence is so many days he absent. Our affidavit we have seen, in the 30 days, he 21 days absent, 25 days absent, like that. Our affidavit is there. Our affidavit and latest, I think, directed to obtain instruction, I think. It is the 4th February 2024, after filing of the affidavit. This is clear, This is clear, no Supreme. The no dues is pending. Termination, so far termination is concerned, notice is given. That is his challenging. He was only consultant. Fishery consultant. Fishery consultant. And he was engaged for time-bound project. That is the World Bank they have taken to do something in that time-bound. But he absent, without he absent, whatever some Soikia has been given, replace him. Because it's bound.
But that is true, madam. Now he is no more. The work is before your lordship, madam. Regarding small amount, madam, very small amount, madam, 30,000 per month. That is for lordship.
So if it is there, then I do not object it. They says instruction says there is no any dues. That's why I cannot say. The action will be given.
But madam, in our petition, madam, we have taken this ground that our salaries has not been paid, and DFO, madam, he did not allow me to put my signature in the attendance register. That plea we have taken, madam, earlier. my lord, the salary which was held up, my lord, that was from January 2021 to June 2021. That total amount would be 1,80,000. And during that period, my lord, only rupees 49,000 was paid. So, my lord, if this
No,
is allowed.
Mr. Das, the first and foremost, you say that you were you had a mental illness.
Yes, ma'am.
Correct.
Yes, ma'am.
Now, for that, I find that there's an extra 5 page 28
Madam.
to that effect.
Madam.
Now, if there's nothing on record to show, because you see there's a difficulty, Mr. Das.
Madam.
Under the Mental Health Care Act
Yes, ma'am.
2017,
Madam.
the court cannot take cognizance of a mental illness unless it is certified by the competent authority. So therefore, the court cannot make an observation to that effect. Now, you have to substantiate it with something to show that this is a period where you could have been treated as
in service.
In service. Because the second aspect of it. You see, your job is otherwise temporary engagement.
But contextual, but I'm working since 2006, my lord.
So that's okay.
2006, my lord.
No, Mr. Das, that's why we are saying. Not to say that you are working, but you see, you're ultimately a contractual employee.
Yes, contractual. The project is, my lord, still going on.
No, that's okay. So once you are a contractual employee, the service become determinable service. So therefore,
my case was that at para 9 we have stated that the district fishery development officer, he did not allow me to sign the attendance sheet, madam. Since the attendance register is with him, that we have taken, we have taken, madam. Now, since we are terminated and he expired, madam, we getting only small amount, madam. It will be around 1,31,000, madam.
no, it's not a question of amount, it's a question of
Entitlement.
entitlement to it.
Our affidavit, page 14 series, my lord. He absent and Lakhimpur, he untraceable and left the office premises without any prior intimation. And how register not to put his signature if he register under his control, he does not write, my lord. He is untraceable, left the office without any information, and the project is time-bound project. It's taken loan from the World Bank. So in these circumstances, his absence is not hampered this work. Definitely, my lord, the officer, controlling officer asks and someone will be replaced. Accordingly, this week has been appointed. And as per rules is there, also temporary officer, we have annexed here, our affidavit. Provision is there. The SDP approval SP termination disposal basis without assigning any reason by giving any 1 month. Service of any contextual consultant, staff, government employee on deputation is found to have indulged in corrupt or fraudulent practices or involved in a criminal case may be terminated by SBO with the approval of the so-and-so notice. And repeated misconduct by any contextual staff or misconduct employees or deputation service basis after issuance of warning in past shall lead to termination of service without assigning any notice of claim. That is also there. Even if he was given 1 month notice.
Para 11 of your affidavit. Not para 11 of their affidavit, madam. They are stating about some ESA policy. They have also annexed that copy, madam. Regarding madam, the ESA policy, since a defined agreement was signed between both the parties, that ESA policy will not be applicable, madam. And moreover, my lord, without doing a proper inquiry, my lord, he cannot be terminated. It will be against the national justice, my lord. If an employee, contextual employee cannot be terminated without my lord, having a proper inquiry. That
no, not required.
So,
my lord, we have got lot of decision, my lord. This court also, my lord.
So, course notice was issued.
No, I don't know. I only refer to that APSC matters.
My lord.
Where it says that it was not required because there is no contract. Once there is no contract, question of giving you a notice for before termination will not arise.
But in this case, my lord, context was there, my lord.
No, it's not there.
It's a contextual job, my lord.
No.
We have got agreement, my
The
lord.
contract is for 11 months. We don't find the extension of contract.
Consultant or engagement of
Yes, ma'am.
consultant, like.
They may not extend the extension, my lord, but within the contextual period, they cannot terminate, my lord.
No, the contractual period, you see, is only 11 months. There is a
Okay.
document to that effect
Yes,
somewhere in the
Yes,
report.
my lord.
I don't find any extension order of that contract.
Even initial appointment is not a next year.
No, it's there. One document is there. It shows 11 months engagement. This
Yes, ma'am.
document I can't check.
That is the agreement, my lord.
The agreement is 11 months.
No, no.
Extension of that is.
But that
is
goes
not
renewal
available.
every month, my lord. That goes renewal, my lord, on every year, my lord. This is, I am working since 2006, my lord.
But, Mr. Das, you are relying on this page 24.
Yes, my lord.
I have-
24, my lord. 24 is here.
What-
Director of Fisheries.
No, what is the incorrect statement given by this?
We said that since this letter was issued against the district official by the director, so my lord, as a revenge, my lord, he took us these steps.
No.
This was
You
present
see,
in our case, my lord.
I'll show you the sequence.
My lord.
You see. You have produced a discharge certificate in page 20.
Yes, my lord. Yes, my lord. 20. From 4/3/2021 to 19/3.
Now, this is 4/3/21
21.
to
19/3.
3/3/21.
My lord.
Then you again give a medical certificate.
Yes, my lord.
It's somewhere
My lord.
where you say that, page 23. Now, this is a certificate that you are ill from 24/2/21
My lord.
to 27/4/21.
Yes, my lord. This period, my lord. Yes,
Correct.
my lord.
Almost 2 months.
Yes, my lord.
Now, you see, there's a difficulty here because this certificate appears to be a fake and false certificate. Reason being 24/2/2021, 27/4/21, but during that period you were in, you were in Gopinath Bardoloi Hospital at
yes.
Tezpur.
Mental
That is
hospital.
4/3/21 to 19/3/21. So this certificate could not have been issued in the first place, number one. Correct?
No, this is April. Up to April.
I understand, but
Yes, ma'am.
during this period you were in hospital.
Treatment,
So BB Civil Hospital could not have given you a certificate
my lord.
when you were in domiciliary hospitalization in Tezpur.
Yes, my lord.
Correct?
My lord. Yes.
That is number one.
No.
The second part is that you come to you come to this absentee certificate
My lord.
at page 34 onwards. Correct?
My lord.
Now here it says he was present days is 3. Page 35.
Yes, my lord.
Present days is 3.
Present date. Days.
In the month of April.
Now, second is
My lord.
the certificate of the April.
My lord.
3 days are given here.
My lord.
Correct?
Mm.
Entered in office is 1, 2, 3, 4, 5, 6.
My lord. Yes, my lord.
Correct.
Good, man.
Now, Saturdays, Sundays, we don't know.
My lord.
Therefore, maybe perhaps Saturdays, Sundays is excluded. And present days is 3. Page 35. Now, next page is
My lord, May 37.
May.
My lord. May 21.
May holidays, present days is 19. And out of these present days, this 19 is work from home. Correct. So others, there's a holiday.
My lord.
A page. absentee statement of 24. Sorry, page 41 is 24 days. These are all work from home. Correct.
No.
Now, in this relevant period of absenteeism from 24 to 21 to 27 for 21, what is wrong in this page 24? The officer may be confused.
No.
You don't find anything confusing. I think
As
the
you have
director of fisheries is unable to appreciate what is happening. He does not know to read absentee certificate. The first certificate is number of days excluding holidays. So if in January, normally you will find 22 days working days in a month. So others are holiday. So therefore the absence statement says working days less government holidays.
Not legal.
And then second sheet says what are the days he was present. So what is wrong? Misleading communication.
Ma'am, that period is January 2021 to June 2021, that period, madam. We are on that period, madam. January 2021 to June 2021.
Yes.
During that period, madam, I was paid only rupees 49,000. Rest, madam, I am entitled for 1,31,000, madam, for that period. January
So
2021.
that means salary for the period you have not worked.
This period.
But this period I was present, madam. January 2021 to June 2021. This period I was present.
No, it is your own showing that you are not. You see, 24 to 21 to 27 for 28 is your certificate saying not present. So the only question can be if this period of absence can be condoned to be treated as on duty.
Page 45 is not correct, manipulated one. Attended office, then it's cut, work from home.
No, because that is COVID period. Your peak COVID period.
Yes.
But that is under their custody, not under.
July.
Okay, so it's a COVID period. I know of these days because I was suffering from COVID at that time.
I also lost 2% of my family.
Huh?
I also lost 2% of my family.
Oh, is it? I'm so
No.
sorry. In my family, there were 4 deaths.
Madam, my elder brother and my mother.
Oh, I'm so sorry.
In a period of 9 months.
I'm so sorry.
I was also suffering, but I did not feel anything. I was in confined in a room, but I did not feel anything.
No, I also did not feel anything.
Sent to nothing.
I was confined. I did not feel anything adverse. But still, COVID at that point of time was very
COVID was a crucial
fearful.
time.
The fear was more than the disease.
We were under all mortal fear.
Fear, madam.
When the deputy commissioner's office was informed about my illness, executive magistrates and all came. They did not enter into the compound. They said, okay, one is there. And I said, okay. Mr. Sutia,
Hello.
considering that he has expired, please
Yes.
tell us a way where this period of leave because of his medical condition can be treated as on work. Can your authorities be asked to examine that?
All of it can direct it to examine it, my lord, because up to them, my lord, because SOPA is a contextual like a consultant. So if he absent, he will not get it because he is
absent and without any information, he left the office. Without any information, he is not coming to the office. And like that, also report is there. Our affidavit is clear.
Where is that report?
Lordship kindly see page 14, our affidavit, Annex H. So this type of person, page 14, our affidavit, affidavit filed by respondent number 3. A, points wise, B. After his joining, he was quite irregular in performing his duties as informed by DFDO concerned, and hence DFDO Lokhimpur was not able to submit his absence statement in time. Accordingly, from July to December 2020, DFDO Lokhimpur has submitted his absentee statement on the day while he present on duties, and accordingly we have disbursed his salary. After that, as per a letter from DFDO Lokhimpur, he was untraceable and left the office premises without any prior intimation since 6 January 2021.
We will tell you something, Mr. Bhutia.
My lord.
Under the Mental Healthcare Act, if he is rehabilitated, if he has recovered, so then you could not have used this word. You see, here you say, after F, last line.
Yes.
For last 2 lines, further it's stated by Thornton he was admitted mentally, so it is also a matter of concern to do the works with him. Under the Mental Healthcare Act, you can't take an adverse step against him for that. But this mental health certificate.
And discharge is there, madam. Admission and
No, discharge is there, but
Madam, I think that this was issued by the doctor. I think that he was also under his treatment, I think, my lord.
No, without appearing in the medical board, my lord, they cannot have the certificate. They could have, my lord, place him in the medical board if it is correct. The medical board is certified that actually he is a mentally so and so, that is acceptable. But he is only discharged from the hospital. There is no such type of medical board reports. And considering his nature of job, nature of engagement, so he was absent without performing his duties. It's a time-bound project. That's why, we have given the absentee statement in page number 16, our affidavit. 31 days out of 30.
Mr. Roy, sorry, Mr. SP Das. You better adjourn the matter today. You take a call. You see another reason why I am adjourning it. You please come to page 20.
Yes, ma'am.
In page 20, you will find that there is no finding by the doctor that you are suffering from a mental illness. Correct. If you turn back, the next page, presenting complaints, you read it, you'll understand. I may not speak it loudly.
Yes, yes.
Correct. So it's not a case of mental illness.
Yes, ma'am.
Excessive alcohol.
This is also,
No, but this is not mental illness. You see, when
that's
you,
why, this court, on the past day, law, this court refused to pass any interim order, seeing this word,
no, this one, you see, I'm not on that. I'm on very technical reason.
Yes.
You see, we are considering Mental Health Act 2017.
Yes,
This is not a condition in Mental Healthcare Act.
Alcoholic problem.
So therefore, it will lead to dismissal. So we give you an opportunity to please check it out. This is only because the person has died.
Yes, that's the conversion, my lord. That is the conversion.
This is
Yeah,
and Mrs. You also find out if this period can be considered by the authorities as a period
taking him on duty.
No, not taking him on duty, but to consider that to be a what you call a period where
January to
January to June.
January to June.
For that, we can receive his salary. I'm not on that. Because it can be a extended leave or something or that sort. It's just adjourn it on that question. To find out, we are not adjourning, we are not passing any orders.
Yes, yes. I will consult it.
Considering the submissions made by Mr. S. P. Das and counsel for the petitioner, that the original petitioner has expired and he is now represented by his wife. And taking into consideration the discharge certificate dated 19/3/2021 within bracket annexure 2 and the medical certificate given by Dr. R.K. Goswami, SDM and HO, BP Civil Hospital, Nagaon.
SDM.
The Mr. T.C. Shutial, an additional senior government advocate, shall make an attempt to obtain information of the instruction as to whether there is any possibility of treating the petitioner on medical leave, just to entitle him. Yes, the husband of the petitioner, substituted petitioner, is on medical leave. So as to entitle the husband of the petitioner, substituted petitioner, to salary for that part, for that period.
January to June.
From what is this, 6/1?
January 2021 to June 2021.
January 2021 to June 2021.
I will obtain.
Next to that, the learned additional senior government advocate is permitted to send a downloaded copy of the order to the competent respondent authorities to obtain instructions. Next paragraph. The observations made herein, made in this order, shall not create any right in favor of the petitioner when the matter is heard. He says, this I'm returning it back. Your
I will check
instructions. Your instructions. Okay, let's stop. Give a date. After how much time?
After 2 weeks. No?
After 2 weeks. Give a date after 2 weeks.
8th of June.
When is the counting start? When will the counting will start? When will the counting start?
Counting 4th June.
No, June, then give it after that.
5th June. That we'll have to see.
No, that's why.
What is
10th, you make it 10th?
10 June.
Okay.
10th of June.
Conflict between brain and heart.
Yes, madam. Okay, I can also do.
একটু উঠাই নিব পিছত খালি এইটো ৰাখি দিব